the United States Court of Appeals for the Fourth Circuit are admonished to draw an eye and give their attention, for the court is now sitting. God save the United States and this honorable court.
Ms. C. Yeah. Ms. Tryman.
May it please the court. This case turns on the immigration impact of an aggravated felony conviction.
You just speak up a little, please.
This case turns on the immigration impact of an aggravated felony conviction. As the court knows, aggravated felonies are game changers in the immigration context, and they're categorically different from other kinds of offenses because they result in automatic deportation, even for aliens with legal status, such as legal permanent residence. Notice that someone is at risk of removal or faces the possibility of removal is, as courts have recognized, not sufficient to warn them that they face mandatory deportation under an aggravated felony. The district court erred in this case in determining that Mr. Nunez Garcia's habeas claim accrued in the when he was sentenced in the Eastern District of Virginia in 2016. He knew at that point that he would have to fight deportation, but he did not know, and he was not on inquiry notice of the fact that he had been misadvised by his.
It would be nice, we're across the room and talk as if you're talking in a classroom.
Thank you, Your Honor. Is that better? So he did not know, and he was not on inquiry notice of the fact that he had been misadvised by his counsel in his 2010 Western District of Virginia case, and that he had already been convicted of an aggravated felony, making any fight against deportation a futile one. With respect to aggravated felonies really are different. And I think that's the first thing that helps to understand.
Let me ask you about what Mr. Nunez Garcia testified to, because he testified in English. I never knew I was going to get deported until 2016 when my attorney in Alexandria explained it to me. I know it was an aggravated felony in 2016. That's when I know was aggravated felony. So if he was on notice in 2016 and he didn't file to 2018, why isn't that in this case?
Because, Your Honor, looking at the totality of his testimony, it's clear that he actually knew in 2018. So previously—
That's not what he said, twice.
Well, what he said once was that he found out he would be removed in 2016, or he found out he'd face removal in 2016. But previously in his testimony, he discusses where he got to immigration custody, he received the notice to appear, and then he went to the immigration law library, realized that this was an aggravated felony and that he had a problem. Looking at his testimony, and he testified that happened in 2018. Looking at his testimony as a whole, frankly, it's clear that he had a problem with dates. He also testified that he got his notice to appear in 2008.
That wasn't a finding by the district court. It was never raised in the district court. So it seems like you're basically asking us to determine by implication at this point that somehow that's clearly erroneous.
Well, Your Honor, the district court relied on a number of facts in determining that 2016 was the operative date. They relied on the advisals that he got in the 2016 proceeding, and they also said he said this in 2000, that got the notice to appear in 2016. Now, he also testified right after that, this happened when he got his notice to appear. He confused 2016 and 2018. If the court has a doubt as to how to balance the facts in this case, then I would submit again, this is a question for the district court. But this was only—
That's not exactly what he testified to. As soon as he said twice, I found out it was an aggravated felony in 2016. Perhaps counsel realized he shouldn't have asked a question he didn't know the answer to, because he only asked one more question. And that was, did you find out it was an aggravated felony when you got the notice to appear? And he says yes, which doesn't exclude the fact that he already knew it in 2016.
Yes, Your Honor. And then
Actually, that, just to build on that a little bit from what I understand about the record, in 2010, he was advised that his conviction could subject him to deportation. And according to him, the testimony of his attorney is a little more inculpating, but according to him, the attorney said, he says, you're not to get deported because you're a citizen. So he knew that he could have faced deportation, but for the fact he was a citizen. He was then told in 2016 explicitly that his citizenship was being revoked. And he was then ordered at the end of his sentence to report to immigration for proceedings, deportation proceedings. Then he says what Judge Agee said, I knew then that I had an aggravated felony in 2016. It almost seems he's playing games by suggesting anything else. He knew what was going on, and then he said his attorney explained everything to him. What's that mean?
so there's a few things here, Your Honor. With respect to what he was advised in 2010, or his understanding from 2010, when we look at due diligence, and just taking a step back here to talk about the due diligence standard under 2255 F4, you look at due diligence in the individual's particular circumstances. In his particular circumstances, although he lost his citizenship in 2016, he was a citizen in 2010 when he was convicted. Between 2009 and 2016, he is a citizen. Now, when he is denaturalized, at that point, he doesn't lose status. He reverts to the status of a legal permanent resident. When he receives the order of denaturalization, that order states that he is being denaturalized from the date of this order. It says the defendant from the date of this order is forever restrained and enjoined from claiming any rights, privileges, or citizen or benefits of citizenship. And so from his perspective, looking at this, he knows that he's no longer a citizen, but he was a citizen when he was convicted. And so he is still relying on his attorney's advice. Nothing that happens in the 2016 proceeding disabuses him of that understanding. When you look at all of the statements that were made by his counsel or by the court, all of them refer to the immigration impact of the 2016 conviction.
If that were so, wouldn't he say in 2016, when he's given all this advice, the explanation by his attorney, he says, I knew it was an aggravated felony. He knew he was losing his citizenship. He knew he had to report to immigration for deportation proceedings. He knew all of these things. Wouldn't he have said, if he thought otherwise, why?
Well,
he didn't say that.
Your Honor, the interesting thing is that unlike most of the cases we see where there's an immigration issue, we have two possible immigration issues and two possible bases for removal. His attorney in 2016 is not wrong. He could have been placed in removal proceedings based on his 2016 conviction. It's a crime involving moral turpitude. The difference is that he would have a claim for relief from removal as a legal permanent resident, just based on convictions of crimes involving moral turpitude. It's the aggravated felony that is the game changer. So this 2016, from his perspective, is a kind of a red herring. He hears all of these things, and it sounds to him like they're saying, because of this 2016 conviction, you're going to be placed in removal proceedings. And I might add that everyone discusses this in conditional terms. his attorney in her sentencing memorandum says he will have to fight removal. Now, that's the very language that in United States versus Murillo, this court determined was insufficient to warn someone who's been convicted of an aggravated felony that they face mandatory deportation. But I'd like to return to the issue of his statements in regarding what he knew when, because he also testified at pages 351 through 354 of the joint appendix that he found out that he had been convicted of an aggravated felony when he was in Florida in deportation proceedings. That is when he received the notice to appear. That's when he gets the notice that says, you are being removed, not based on your 2016 conviction, but based on the 2010 conviction. And he testified that happened in 2008. And the judge said 2008. And he said, oh, that was my mistake. I meant 2018. So I think the court can reasonably infer based on his specific testimony as to where he was and when he was, that he actually knew this in 2018. Later on, we were talking about 2016 and his awareness, his dawning awareness that he would be placed into removal proceedings. And then he said he misspoke, basically. I think that is what the balance of the evidence shows. Now, with respect to, courts have recognized that an alien who—
Where do you say he misspoke?
He misspoke at the point, Judge, that you cited later in the testimony, in the rebuttal testimony, where he said it was in 2016 that he found out it was an aggravated felony. And then I asked when you got the notice to appear, and he said yes. He got the notice to appear in 2018.
And you think those are mutually exclusive answers?
They are, Your Honor, because he is describing when he was at the record at 351 through 353. He is describing when he was in immigration custody, and he did not pass into immigration custody until 2018. So looking at that, I think if the court wants to hang its hat purely on the one time that he says, I found out aggravated felony in 2016, I think there's a serious factual conflict in the record at that point that the court should send this back to the district court. The district court was not relying solely on that, but also on the advisals that he got in 2016. Now, with respect to those immigration advisals and what he was told, courts have recognized that when an alien relies on an attorney's misadvice, he lacks sufficient notice at that point to challenge his immigration.
Well, you know, he explains that too. And there's a good question of whether the lawyer's advice was wrong at all anyway. But in that same hearing, he talked about how he says, when I say I was a citizen of the United States, he say he's good to go. So I say never, was never told me that. So I say, I never say, he never told me that. I believe, I never knew, he's speaking a little bit broken here. I never knew in my life I was going to get deported if I signed these questions. That's because he was a citizen of the United States. So he rests all his reliance on his attorney, advising him that because he was a citizen, he was protected from deportation. That's his assumption based on the advice of counsel. But at that very same hearing, he's told, now you've lost your citizenship and you have to report to immigration. So isn't the natural consequence from that everything he relied on was pulled out from under him at that point? And he also acknowledged that he knew that the earlier conviction was an aggravated felony. And so what more do we need to tell him? Do we need to print out a form or something and tell him this? It's pretty obvious that he thought his protection was based on the advice of counsel. I'm a citizen, I can't be deported. Accurate statement, right? And then he comes in 2016 and he recognizes and he says, that's what I relied on. But in that very same proceeding, then his citizenship is taken away. All right, I understand what you're saying, that, you know, his language isn't perfect and he's putting together historical facts, but it looks to me like the deportation issue came to the table in 2010, which would be unusual because if he really was a citizen, clearly at that time, you would never have that in the report. So in the Senate's agreement and in the explanation by the attorney, he sees the deportation and the attorney says, don't worry about that, you're a citizen. That's according to him. The attorney, of course, says more clearly that if you signed wrong and all that other stuff, but let's set that aside. So the deportation is on the table from the beginning. And then it comes up again in 2016 with a lot more facts. And then he has a statement. His attorney at that point explained everything to him.
I see my time is up. May I respond?
Yeah, obviously it's yeah, sure.
Thank you, Your Honor. So when he loses his citizenship in 2016, he loses his citizenship from the notice that he gets as of the date of that order. Now, looking at what he knows, it's saying from this day forward. But he also knows he was a citizen in 2010 when he was convicted. The difference is that I think this is the mistake the district court made as well, is saying once you know that you face the prospect of removal, you should be charged with knowing everything else. And I think that that's not how courts have typically, where they said a generalized advisal about the prospect of deportation is not sufficient. You have to tell some issue that changes his status is the aggravated felony conviction. Unusually in this case, the thing that makes a difference for him and for his removal is not as much the loss of citizenship, although that is what enables the things that the changes that happen to occur, but the aggravated felony conviction. Absent that aggravated felony conviction, he would have had a defense to removal. And so that is the thing that he needs notice of, and he receives neither actual nor constructive notice of that. Thank you, Your Honors.
Thank you, counsel. Mr. Juan.
May it please the court, Kegel Juhan on behalf of the United States. This is a statute of limitations case. And if I may make 2 points, one about the record and one about the law before going into some of the discussion here today. The first point about the record is one that's been talked about already, is that Mr. Nunez Garcia testified under oath in black and white in the record that in 2016, he talked with his EDVA attorney about the 2010 conspiracy conviction. And he went on further to say that that's when he knew in 2016 that that conviction was an aggravated.
Mr. Julian, why don't we start, as you did very aptly, that this is a statute of limitations?
Correct.
Tell me, what is the date that he was deported?
The date that he was deported?
Yes.
I don't have that offhand, Your Honor.
You don't have that offhand in the statute of limitations case? Wouldn't that be the triggering as to whether or not someone has to avail themselves of appealing as a result of that? You don't know what the date he was deported?
Your Honor, that's not the triggering event, because the important thing here is the legal test for F4 purposes is different from the merits test, the constitutional standard in Padilla. And here today in the briefing and below, I think that has been conflated a little bit and confused. There is the substance.
So you're saying it doesn't matter the date that he was deported? What
matters is when he had notice, and this is from this court's opinion in Caro, which was unpublished, citing the Seventh Circuit.
Does it, okay, by statute, does it say who the notice must come from?
It says that the individual, the test, the F4 test, as other courts have said, and as this court in Caro said, is what matters is it's an objective inquiry, and what matters is not knowledge of the law, but knowledge of facts that would put a reasonable person on inquiry notice that they need to have a potential claim here. And so when we
That they need have a potential claim.
he just had to know the facts, Your Honor, and he didn't actually have to know the facts. He had to be on inquiry notice of facts that gave rise to the claim. And so we have to start by defining.
So if he was never, suppose he was never deported. I mean, so in other words, you just have noticed something never happened. So then, I mean, so like for example, suppose he was deported 5 years later, then his chance to appeal that would be over if he found out 5 years later. 5 years later, he's actually deported, but 5 years earlier, he had what you call notice.
It's not what I'm calling, Your Honor.
Well, I'm just saying, I don't mean that, I'm not trying to twist your words. I'm just saying, you said that this was the appropriate notice, correct?
Correct.
So my hypothetical to you is that if you get the notice that you said that's enough to trigger inquiry 5 years earlier, but 5 years later you actually deported, you're saying that it would be too late for him to even avail himself of any appeal. Is that your argument?
Your Honor, my argument
is that your argument?
No, sir, Your Honor, it's not. And here's why.
Okay.
A couple points. One, what matters is notice of what? And the standard is not notice of the bald fact of you are being deported today. It's notice of facts that give rise to the alleged ineffective claim. And so you have to look back to the merits to say, what is the alleged ineffectiveness here? The alleged Padilla error is that his attorney told him, you can't get deported because you're a citizen.
Right.
So that is the predicate advice. That's the key fact. It's the fact of his citizenship that protects him. It's the shield from deportation. So then when you fast forward 6 years and he now knows that that shield has been stripped from him, that is the critical fact, or one of the critical facts. It's the easiest one to rely upon that puts him on notice. Okay, you're alleging that in 2010, your client made, or your counsel made, a Padilla error. It's not a Padilla error because he was advised accurately, but setting that aside, he didn't have to be on notice of the bald fact of you're being deported now. What created the notice was the alleged advice. The predicate is now gone. And I would direct the court to this court's opinion in Gadsden. It's cited in the briefs. It's a published case, and the Supreme Court's subsequent endorsement of that test in Johnson. And those cases are important because they involve a situation where there's a predicate fact that is based upon a federal sentence. So those are career offender cases where there's a predicate fact of conviction in the state court. And then that predicate state conviction is overturned later. And what Johnson says and Gadsden say is when that predicate is gone, that's when the clock starts ticking for F4 purposes. And that is like this case, except the predicate here is the status of citizenship. And so once he knows in 2016, when he's sitting in the Alexandria courtroom and his attorney has said, you're going to enter into deportation proceedings, and he's told by the judge, you've lost your citizenship. He knows what he was advised before. Your citizenship is your shield. And now he's on inquiry notice, and this is where it's important to focus on what the F4 statutory standard is. It's an inquiry notice standard. That is a separate analytical box from what the Padilla analysis is. And in the briefing and here today with the citation to Murillo, Akinzade from this court, Padilla, Murillo, Swaby, those are all merits Padilla cases where you take the alleged advice and are asking on the constitutional question, has this individual specifically been disabused of the allegedly wrong legal advice? It's more akin to an actual knowledge standard. But in the F4 context, in the statutory context that Congress has crafted this statute, it's an inquiry notice objective test based on the totality of the circumstances. And what matters are facts, not the legal significance that follows.
What if the judge had told them, I don't know what this portends for your immigration status? Would that change the case?
Which judge, Your Honor?
The judge in 16.
If that judge had said,
I'm not sure what this portends for your immigration status.
He's still on notice that the citizenship has been stripped from him. And he's
on notice because he was convicted of a statute, an aggravating offense, right?
He's on notice under 1425. That conviction carries with it a mandatory stripping of a naturalized citizen's citizenship when you procure your citizenship by fraud.
So it's mandatory.
The stripping of the citizenship under 1425, yes, is my understanding is mandatory. And the district court, of course, orally advised him of that at the time.
But that's the stripping of citizenship is included in a district court's order in that circumstance.
That's correct. There is a separate order that's also entered in the record in the EDVA that's part of the record in this case.
Yes, these questions that Judge Gregory are raising, they're good questions, I think, in regard to determining an F4 claim. And I'm wondering, really, the difficulty in this case is the claim is that my counsel was ineffective in 2010. That's a Strickland claim. And if he says the ineffective assistance was because I received the following advice, that I was a citizen and therefore I would not be deported, even though he was told that the possibility of deportation. The difficulty is that's probably, as he stated, it is probably not an ineffective claim. It's an accurate statement.
Correct, Your Honor.
And so the difficulty in this case for the courts and for him, the lawyer was ineffective. And his argument has to be that somehow, forever, and so then if you accept that as the object of the claim, the 2255 claim, I suppose that in 2016, when he's before the judge and he has his citizenship revoked and he's told to report to immigration, does that at that point make the lawyer's statement in 2010 ineffective?
Your Honor,
he has to be maintaining that, right? I mean, I don't know what aspect of the lawyer's advice was he's relying on his Strickland claim. He's basically saying, if I knew I could have gotten deported, I wouldn't have pled guilty. That's basically the underlying thing. I don't know how that gets him a lot, because then. But let's assume that he pled guilty because his lawyer advised him he would not be deported because he's a citizen. So in 2016, the citizenship is removed and he's ordered to be deported. So at that point, that's the only point in time he could conclude that his lawyer was ineffective. It's not a question of whether he would be deported. It's a question of whether his lawyer was ineffective. So when did he learn that his lawyer was ineffective? Or when could he claim that his lawyer was ineffective? And I suggest that maybe the only thing he could claim is that I thought I was going to keep my citizenship forever and I would never be deported.
A couple of responses to that, Your Honor. One is that even if that were to be the nature of the alleged error here, that the attorney in 2010 didn't say more and speculate about future, well, but if this happens and you lied and then you find out, the government finds out about that and it prosecutes you, then you could be stripped of your citizenship and then you would be deported. That's not a Padilla error either, because Padilla talks about the immigration consequences to be triggered, the Padilla duty, they have to be clear and certain. And so when there are speculative immigration consequences, that's not a Padilla error either. So our position is—
Well, you're just going on to argue that the lawyer never wasn't ineffective at all. I'm trying to take it from the petitioner's point of view here. And his point of view is, I was told that I would not be deported because I'm a citizen. And he repeated that numerous times.
At 349 is when
you repeat it. So that's not an issue. So now he claims that that is the ineffective advice he got. So then the question comes, when did he learn that that was ineffective? And the only thing I can speculate to trigger the exception to the 1 year limitation period. Of course, the limitation period runs from 2010. for 1 year. He gets a suspension of that to the extent he didn't know, and with inquiry notice. So I guess my question here, and I probably should pose it to his lawyer, but it seems to me it's not when he knew he was be deported, it's when did he learn his counsel was ineffective under Strickland? Or when should have he known that his counsel was ineffective with Strickland?
Of course.
And it seemed to me, if you phrase it that way, he learned almost everything he ever learned in 2016 to the extent he assumed differently.
I think, Your Honor, that is generally correct. That is essentially what the district court said in its holding about the importance of 2016. Of course, below, although the district court didn't rely upon this grounds, the government's position.
Well, I'm troubled a little bit by the focus on deportation and when's he learned he's going to be deported and all that. And it seems to me when you're talking about whether an attorney is ineffective, that isn't the issue. The question is he was given information in 2010, which he alleges was ineffective advice. And so now the question is, when did he learn that that advice was ineffective or wrong? And it seemed to me everything about that advice that could be challenged, he learned at 2016.
I think that's right, Your Honor. I mean, I think he learned about it at 2010 when I
shouldn't be asking you, I should be asking your colleague this question, but I had trouble with this in reading this record. I'm sitting there thinking, well, what was wrong with that statement by the attorney? And then the attorney himself testifies and explains that there was some doubt about the truthfulness of questions to obtain citizenship. But I think Garcia really disputes that and really says, I was told that I would not be deported because I'm a citizen. So deportation was on the table. That was his concern. He got advice about that. That particular statement, without more, is not inaccurate. It's not wrong. And so now the question is, he said, I pled guilty because of that advice. I wouldn't be deported because I was a citizen. It seemed to me the first time, and maybe the only time, he would learn that advice was challengeable was when the citizenship was in fact taken away. And he was then more than that. He was told that that advice was either right or wrong, or the assumptions he built into that advice. In other words, the inquiry notice is a broader protection for the
correct, Your Honor. But you're right. I mean, I think the fact that he knows what he knows in 2016 makes the case for affirmance an easy one. Now, of course, the government below has it argued, and the court, I think, could affirm on this grounds. It could also affirm on the grounds that are apparent in the record that there's just no Padilla error here. The court can always affirm on grounds that are apparent in the record, and it wasn't erroneous advice to say what was true at the time. Your citizenship shields you. But setting that aside, he's advised by the magistrate in 2010, there may be deportation consequences here. And so when you read the Clark case out of the Seventh Circuit that we cite in our brief, that's that case. I mean, that's an individual who was a non-citizen even, who was on inquiry notice and is told, there could be deportation consequences. Again, and Clark is an F4 case. And I understand that factual scenario might not meet the substantive standard under Aiken's aid, or arguably wouldn't under this court's merits Padilla cases. But on the F4 inquiry notice, which is a lesser test, it's a harder test for a defendant to satisfy, that in 2010 he's on notice, and certainly by the time you get to 2016, he's told you have no.
Yeah, but see, the notice, you keep coming back to my problem. The notice isn't notice of deportation. The notice is ineffective assistance of counsel, erroneous notice. If the attorney told him illegal advice, then the question is, when did he learn it was illegal? And so it's not a question of when he would be deported. It's a question of, he was concerned about deportation. He asked about it because he was advised about it, and he was assured your citizenship, you won't be deported. But the question is now, he claims that was improper advice, and I don't understand fully what he's saying. And I'm to give him the benefit. I'm assuming that what he's saying is, I thought that was perpetual as long as I was a citizen. I can't read anything else into it, because he said he testified twice, never in my life did I think I would be deported. And I think that's because he was a citizen. But the first time he gets some inkling, actually he gets actual notice that that is a misstatement or misassumption, is when he actually loses his citizenship and is told now to report to the immigration authorities. Anyway, it makes it a little dicey as to how to answer Judge Gregory's questions, is when does the statute run? And I think the statute runs when he's on imputed notice that he has a claim. And his claim here is a Strickland claim.
Your Honor, our position, based on Caro and based on the citing the Seventh Circuit's case in Owens, is that the notice runs when there's imputed notice of facts, not their legal significance. And so then the question is, what are the facts that would put a reasonably diligent person on notice of a potential Strickland claim that they ought to relate back and start investigating? And so by 2016, he knows his plea agreement in 2010 says you may be deported. He knows that WDVA judges told him that too. He knows he's not a citizen. He knows from what the EDVA attorney has told him that
he doesn't know he's not a citizen until 2016.
Correct.
So the inference, the assumption he has to be making is that he assumed his citizenship would protect him forever. In other words, it was not dependent on his citizenship. And so, I mean, he's reading into that advice as he explains that I was told that because I was a citizen, I wouldn't be deported. That's all that he reports. But he has to be assuming, in order to have a Strickland claim, that there was more to that. He assumed it probably was more permanent. My point is, I suppose, is that that assumption is opened up and undermined by the fact that in 2016, not only did he lose his citizenship, but he was then told he was subject to deportation. And apparently it might have all been explained in greater detail, because he said, my attorney explained it all. I knew it was an aggravated felony and this type of thing. But I think the focus has to be on what he assumed was ineffective assistance of counsel, and when that assumption of an ineffective assistance was known to him. And I don't think that has anything to do with the actual facts in the world. This is a 2254-5 claim.
So, Joanne, what's the date you said he lost his citizenship?
Would have been January 8th, 2016.
He actually lost it.
Yes,
Right.
He is, yes.
And that occurred by what process?
That occurred by the process of in the 1425 prosecution in the EDVA, when he is charged with that crime and convicted of that crime. And then at the sentencing, there's the presentation of the order to Judge Tringa to denaturalize him. And so that was the process. That was what the litigation was essentially about. I mean, that was the core thing.
It seems to me the judge entered the order right in the proceeding, didn't he?
Correct, yes.
He signed it right there and told him to sign it.
Yes, it was handed up in court. I think the record reflects that the judge asked, I think the defense attorney even said at one point in time, I understand the government's going to present a denaturalization order to the court. And at one point in time, the judge says, do you have an order for me? And the government hands it up. And that's the denaturalization order that is entered while he's there in that proceeding in 2016.
Okay, right.
If there are no further questions, I thank the court. We ask that it affirm.
Thank you, Mrs. Joanne. Ms. Trotten, you have some time left.
Thank you, Your Honor. So my colleague was asking, what's the fact that he was missing, that he should have been on notice of? And the Seventh Circuit recognized in Clark that misadvice by counsel is a fact. And so that—
No question, we don't need to go to the fundamentals of the cases. Let's focus on this case. He claims that his counsel was ineffective in giving him advice in 2010. And the ineffective claim he makes is that my counsel told me I would not be deported because I'm a citizen. And deportation was on the table and he was told about it, but he was assured because he was a citizen, he would not be deported. That's the ineffectiveness, right?
Yes, with one slight adjustment here. And I think it's important to recognize he was told he would not be deported, or he understood he would not be deported based on that conviction.
Yeah.
So this doesn't occur in a vacuum. It occurs with respect to 2010.
Well, yeah, the only conviction on the table was the 2010 conviction, and they're talking about it, and he gets this advice, and the attorney tells him, because of this conviction, that's all before them. You're not going to be deported because you're a citizen.
Yes.
That's ineffective, he says. Now, first question is, what's ineffective about that? What's wrong about that? And my assumption is he must assume that he'll never be deported as long as he's a citizen, or he'll never be deported. I don't know what the assumption is, but let's just say it's one of those two things. He's dissuaded of that in 2016 when the facts proved to the contrary. So now he knows that what the attorney meant is so long as you're a citizen, you won't be deported. And he was told you're no longer a citizen and you're going to be deported in 2016. But not only that, he doesn't focus on that action. He talks about recognizing it's an aggravated felony that's causing the problem. And he knew of that fact in 2016. And his attorney explained it all to him. Now, the question is, when did he learn of his Strickland claim? Not whether he's going to be deported. So you got to focus first on what was the ineffective advice that he learned, and when did he learn it?
He learned it in 2018 when he got a notice to appear that said, you're going to be removed based on this aggravated felony conviction. Up until that time, he has...
What was ineffective? What did the attorney say wrong?
The attorney said, you're not going to be removed based on this conviction.
No, he did not.
He said, you're a citizen. You're not.
He didn't talk about this conviction at all. It was that implied. What he said is that because you're a citizen, you will not be deported. The only thing he was advised that his shield was based on his citizenship. And he repeated that 2 or 3 times, as did the attorney.
Yes, Your Honor.
Okay, well,
So
I'd like to know what aspect of that was wrong and when did he discover the aspect that was wrong. And I'm giving him gratuitous assumptions to say that there was some further aspect about that the attorney said, well, if you aren't a citizen, you're going to be deported, which is the flip side of that. Maybe he's relying on that, or maybe he's relying on the fact that he'd never be deported, because that's what he said. I never thought I'd ever be deported. But both of those assumptions, which I'm not sure he's allowed to read in that, because at that point in time, he knew of the facts. He knew of his difficulties with his citizenship. But quite apart from that, he clearly knew that his assumptions were wrong in 2016. And it didn't make the advice wrong. It just made his assumption about that advice. But I don't know what your position is as to what was error in that advice by the attorney.
So the substantive Strickland claim I could certainly go into, but probably not in 43 seconds.
Well, that's the whole claim. This is a 2255 based on Strickland.
It is, but we're talking about timeliness here. Now, the actual...
No, but the timeliness is based on knowledge of the claim.
Yes.
And the claim is Strickland.
Yes, and so the error that his attorney committed was in telling him, when they're talking about you won't be deported because you're a citizen, they're not talking about it in a vacuum. As you recognize, they're talking about it with respect to this methamphetamine conviction that he gets. When he gets his plea agreement, he testified that he goes and he talks to his attorney and he says, what about this? Says I face a possibility of removal, and he says, don't worry about it, you're a citizen. So looking at that in the totality,
right?
When he is a citizen, now the difficulty is his attorney realized
advice that if you lose your citizenship, you're going to be deported. That's what you're saying was ineffective. In other words, he didn't add on that if you lose your citizenship, you'd be deported.
Well, his attorney recognized that his citizenship was problematic.
Yes.
He told him he wouldn't,
And as attorney, if you accept that, you have to accept the attorney's advice. And the attorney told him that. And the attorney told him, if you're not a citizen, then you're in trouble.
Well, again, when we get to weighing the evidence, these are questions that the district court didn't
I'm
reach.
trying to give him the benefit of doubt and excluding the attorney's evidence. In other words, I'm trying to focus on his claim of ineffectiveness. And his claim of ineffectiveness is the one statement, and that's all he said. So you're suggesting that something implied in that statement where you said, if you're a citizen, you will not be deported. He didn't say because you are a citizen, you will not be deported. Something in that is ineffective?
Yes, Your Honor. And that's set forth in the briefing. I see my time is up. May I respond?
Well, counsel, yes, you may respond, but I have some questions to you. This, because give you time. Obviously, all these cases are important. This is certainly very important. Make sure I understand your position. In 2010, as I think as Judge Niemeyer has aptly said, that's where the Padilla problem comes. Two things. You're a citizen, so you're good to go. Two, as you added, that also this actual offense or conviction doesn't trigger it either. So that's 1 and 2. Let's call those shields. What I want to question is this: when it gets to 2016, because the conviction is different now, one, because the status of citizenship is different now, two, because he's told, and actually the order is signed right before him in open court. What then allows the Padilla problem of 2010, which is being under wrong advice, to extend beyond 2016? That's my question.
Well, in 2016, when he loses his citizenship, and then he's now a legal permanent resident,
right?
He's told that he faces the prospect of removal. That's clear. But he could have been removed based on the 2016 conviction, in which case he would have a defense to removal. He does not know what the basis of removal is going to be until 2018, when he gets that notice to appear. And it doesn't say crime involving moral turpitude. It doesn't say you're removable.
But you don't assert that his lawyer told him something anew in 2016 that was wrong.
So I think
is that right? You don't assert that the lawyer told him something anew in 2016 that was wrong.
No, correct? Your Honor.
Okay.
No.
So, okay.
I think the lawyer was correct. He could have been removed based in 2016 based on that. But there's a big difference, as we've said, between having an aggravated felony and having another type of conviction. Just very briefly, Your Honor, we've been talking a lot about what he said about 2016. But the only statement that he makes regarding his knowledge of an aggravated felony in 2016 is on 422 of the Joint Appendix. Did he ever tell you, did he ever tell you that this methamphetamine charge was an aggravated felony? Answer, no, I never know it was an aggravated felony. I know it was an aggravated felony in 2016. That's when I know it was an aggravated felony. I didn't even know nothing. And then the follow-up question was, did you find out it was an aggravated felony when you got the notice to appear? Yes, correct. So he doesn't say my lawyer told me in 2016 that it was an aggravated felony. He doesn't say anything specific about that. All the things he's talking about his lawyer telling him are related to the reasons that he is losing his citizenship and faces the prospect of removal. So his claim does not accrue until he actually gets the notice to appear in 2018. And he finds then that he was convicted of an aggravated felony that will result in his deportation necessarily, and that happened in 2010. And so for those reasons—
Last question is Judge Agee started us off with, and you just ended up with, he did say 2016. Of course, you said that's evidence of his being misspoken.
Yes.
What's your best argument that that's enough that we should remand this for the district court to clear up that factual question?
Your Honor, the district court relied on a number of factors. Many of them were related to the representations that were made in 2016 in court. And for the reasons I've already stated, those aren't sufficient. if the court wants to hang its hat on this one statement, which is
Well,
directly.
actually, he said it twice because you omitted reading what's on page 421, which I read earlier when I asked you about this.
Well, on 421, he talks about knowing he was going to get deported. But he doesn't.
Right, when my attorney in Alexandria explained it to me.
But he doesn't say that he knows that it's an aggravated felony. The only time he talks about it being an aggravated felony is on 422.
Which is part of the explanation by the Alexandria attorney. That's clear from the questions that are being asked.
Well, his Alexandria, I dispute that, but I think to go to Judge Gregory's question, where you're looking at, he says aggravated felony in 2016, but he also says previously and in much more detail that he actually found this out in 2018 when he got the notice to appear. There's this conflict in the record that the district court never resolved. And so if this is the basis, then it should be returned to the district court for factual balancing.
All the assumptions about the Strickland claim are assumptions that we read into the one sentence advice that you're not going to be deported because you're a citizen. He then says, I never knew in my life I was going to get deported until 2016 when my attorney in Alexandria explained it to me, everything about the questions. So it seems to me if the advice was the assumption, this is what I'm assuming, when he got the advice in 2010 that he'd never be deported because he was a citizen, he had to assume that statement meant, even though the attorney didn't say it, that you would never get deported. That would be the ineffective advice or his assumption. And here on page 421, he says, I never knew in my life I was going to get deported until 2016 when my attorney in Alexandria explained it to me, everything about the questions. So doesn't that put him on notice for the first time that the understanding he had about what the attorney said in 2010, if he assumed it, was a wrong assumption?
No, Your Honor, because he knows in 2016, even when he loses his citizenship, he still had citizenship in 2010. So when we're talking about 2010, we're talking about what he understands about the impact of his citizenship on his methamphetamine conviction. When he learns that his citizenship has been revoked, the reasonable understanding of that would be, I no longer have my citizenship. It's not necessarily clear that he would.
We keep forgetting, we're focusing on the advice given to him. And that sentence I read to you focuses on the advice, which is, I did not understand that I could ever lose my citizenship and be deported. And he now says in 2016, I now learned about it, as my attorney explained. And it seems to me when we're focusing on a Strickland claim, and that's what we're doing. I mean, this claim is brought many years after 2010. Okay, I understand your position, I think. I'm not sure.
Well, I see my time is up. Thank you.
Counselor, you have 30 seconds to respond to Judge Niemeyer or to us. Only 30 seconds. Go ahead.
I'll do my best, Your Honor. So when he is talking about removal and understanding that he has lost his citizenship, he may have understood that he has lost his citizenship, but that does not mean that he understands that his attorney's advice is wrong as to that methamphetamine conviction. That is what matters, not will you ever lose your citizenship. His lawyer wasn't his lawyer for immigration purposes. He was his criminal attorney. And so he could still understand,
That's what you're challenging, is the advice of the criminal lawyer in 2010.
Yes.
And I have not understood what aspect of that advice he claims was ineffective.
Telling him.
And so I've given him assumptions. If you focus on that claim, it's perfectly correct statement.
Telling him that he could not be removed based on, telling him that he does not face deportation, when in fact he does face.
No, he didn't say that.
Yeah.
He said, you will not be deported because you are a citizen. That's what he said. And that's repeated. That's the ineffective advice.
In the context of the methamphetamine conviction. Thank you, Your Honor.
Thank you so much. Counsel, both of you, thank you so much for your arguments. We would love to come down and greet you with our handshakes in our normal tradition, but due to the circumstance, we cannot, but no, nonetheless, we very much appreciate your arguments and being here and wish you all well, be safe and stay well.
Thank you. Your Honor.
Thank you.
And we're all the way across the room, so speak as if you're talking to the back of the classroom.
Okay,
Thank you.
maybe does that help a little bit, the microphone?
It's not the microphone, it's you're get your voice up strong.
Okay,
It'll make a stronger argument too.
okay, thank you. We're here today because the district court denied Mr. Jackson compassionate release without recalculating his guideline range, which would have been 7 years lower without the career offender enhancement. The language of the compassionate release statute 3582 C1A is clear. It tells the court that they have to apply the 3553A factors. And the first one of those steps to consider those factors is a calculation of the correct guideline range. The Supreme Court has said in numerous cases, Gall, Molina, Martinez, Rosales, Morales, that the guidelines are the starting point and the benchmark.
So your argument here is that the error is that the district court was required to recalculate the guidelines?
Yes.
All right.
How do you handle it?
Where did you tell the district court that?
Well, it probably could have been more artfully said, but the argument was that he was no longer a career offender. And I can cite to the JA for where it calculated what his correct guideline range would be.
Right. I know the guidelines, there was evidence or argument that if the guidelines were recalculated, there would be a difference.
Yeah.
My question is, where did you argue this is something you're required to do? Because I'm not sure I find that in the record.
It wasn't stated that this is something you're required to do, but the assumption in every sentencing case is a correct calculation of the guidelines. So the appellant didn't say this is what you have to do first, this is what you have to do second, but the assumption in all these cases is that you will start from the correct range. And here, based on the district court's explanation.
So what compassionate release case says that?
Well, compassionate release case, this will hopefully be the first case that will say that. In other contexts, in every other context, all sentencing decisions, including under the First Step Act, you assume that you have to start from the correct range. And if you don't, it's automatically prejudicial. That's what.
The Supreme Court came down with this decision in Dillon. I don't know if you recognize Dillon.
Yes.
Dillon, you made the same argument that was made to the court in Dillon. And that was you're focusing on criteria for imposing a sentence, which is first calculate the correct guideline. And under the First Step Act, the court recognized that you're imposing a new sentence and that you have to go through the process for resentencing.
Right.
But then it said under this very statute, 3582C, the court said that's a different function. This function, you do not impose a new sentence and you don't go through that process. What it said is you are modifying or reducing a sentence, and the standard is only to focus on what Congress said with respect to that. It seems to be a controlling decision that controls this outcome. I didn't see anybody arguing it. I'm trying to see. Dillon was decided in 2010, and it takes this very statute.
Well, if you look
it distinguishes it from everything you've argued so far, which is, and all those arguments were made, that when you impose a new sentence under the First Step Act, they said it's a new sentence, it's a resentencing. Well, that was what was argued. And the court said that may be so, but this is under 3582C. And then they said under 3582C, you follow a much more restricted.
It's more restricted, but it's not nearly as restricted as the C2.
There's nothing under there that says they pointed that out to recalculate the sentence. That was the whole issue in Dillon.
Well, actually, what the court said was that there's no language in 3582C1A that tells the court that they can't recalculate the guideline range, which is what this court said in Chambers. What made the First Step Act different is both the use of the word impose, which tells you that you're imposing a new sentence, not just reducing it, and also the absence of language telling the court that it's restricted. Now, that was what made it different than C2. And so now we're looking at C1A, which is not as thorough, possibly, as C1B.
Here, you're right on the merits. You're going to the merits of your argument. But as a preceding question, if the court were to conclude that you did not raise the issue that you raised on appeal in the district court, what happens then?
The government has not raised plain error, but they've waived that argument. But even on plain error, the calculation of the guideline range is such an essential part of the consideration of the 3553A factors that, like in Muhammad, this case, it was unpublished, but it was remanded, and because the court came to an incorrect guideline range based on a career offender enhancement that no longer applied.
But that argument isn't on the face of C1A. I'm not aware of a policy statement from the Sentencing Commission on that. I assumed if there were any legislative history, somebody would have cited it. So we don't have any of that.
You're right, we don't. What we have is the contrast between it and the neighboring provision C2. And C2 has a lot of restraint. So Congress knows how to tell the court that you're limited here. And in C2, all you can do is substitute the amended guideline range and leave all other decisions unaffected.
Exactly. C2 is totally different. It's an imposition. Judge Niemeyer is correct. And Dillon would apply that. We're talking about C2. But under compassionate relief, you could let the person who has 50 years left release them, correct?
Only if they met the extraordinary and compelling circumstances.
That's what I'm saying. But
Yes.
the range, is, as you allude to, is incredible. You're not there to impose a new sentence based on guideline changes. It is what it means if there's a fine and extraordinary situation. And what about the McCoy case? Did we do that in McCoy? We were talking about C1A.
Well, in McCoy, this court said
Go ahead.
that the C2 didn't apply to the C1, and it relied not only on the language imposed in new sentence, but it said it was the absence in the statute of restricting language, and it was to give Congress's intent to basically to give meaning to the intent, which was to correct past sentencing disparities. The same thing, compassionate release, Congress passed, said increasing the use and transparency of compassionate release. Increasing the use and transparency, and unlike C2, there aren't these restrictions on what the court can consider. That leaves it open, that puts it a lot closer to C1B than it does to C2. It might not be the imposition of a new sentence, but the calculation of the guideline range is still an essential part of it. And starting from an error, and Judge AG, you said, even if it wasn't laid out as artfully as it could have been, even under plain error analysis, the court started from the wrong spot. And we know that because the court's decision, the court summarized both parties' positions, never said anything about the changed career offender enhancement, and then kept referring back to the original sentencing, which was 6 years earlier with a guideline range 7 years higher, and said the court took into consideration many of the same factors at the time of the original sentencing in determining a 132-month sentence was appropriate. Then again, later it said, this court concludes that the factors were properly balanced at sentencing, and the defendant's medical conditions and current public health crisis do not alter the assessment. So clearly the court was relying on what it had done at the original sentencing. But again, we're 6 years later with the guideline range 7 years lower, which is a lot like the cases. I mean, it's a lot like Rosales Morales and Melina Martinez, when the guideline ranges were actually much closer. It was a 77 to 96 month range instead of a 70 to 87. The court picked a within guideline sentence of 77 months.
How much of your argument relies on an analogy to the First Step Act, Section 404?
We think it's clearer than the First Step Act because the language of 3582 C1A tells the courts they have to apply 3553A. So in that sense, it's comparable in a lot of ways. It doesn't have the imposed language, that's clear, but it meets the other criteria for why C2 restrictions don't apply. But it's also clearer than the FCA because in Chambers, Collington, and Lancaster, C1B doesn't tell the courts they have to apply 3553A. And that's really the linchpin here, is that the statute tells us exactly tells courts what they need to do.
If that's similar, Supreme Court has before it the Concepcion case, and will address the First Act case argument you're making.
We don't think Concepcion really.
This is not a First Act case, is it?
No. This is compassionate release.
Right.
This is compassionate release, which is different than First Step Act for all the reasons you said, but for the purposes of correctly calculating the guideline range, it is much closer to the First Step Act cases than the C2 guideline amendment
So
cases.
if the Supreme Court decides to take the position of 4 circuits that have said you can't recalculate the guidelines in that circumstance, you would say it doesn't matter to your case.
It does not matter to our case because the statute speaks for itself. The language of the statute tells.
It's not a recalculating the guidelines to determine the appropriate sentence. It's just the much more narrow is to reduce the sentence, to modify the sentence. And you don't need to recalculate to modify. You modify it based, in this case, it's a compassionate release, which would be modifying it to the extent of reducing it to time served. And because the argument is he gets out of prison today, but that doesn't require recalculation to justify that. It requires the factors in 3553A.
Exactly.
But those factors basically focus on you're giving up a sentence that has been imposed, and you're weighing that against the personal factors of medical conditions and whatever it is for the compassionate release.
But in order to correctly to do the weighing that's
You're not
required,
computing any sentence. You're just reducing the sentence. In other words, it's not imposing a sentence and
Right.
finding the correct guideline. It's basically just reducing the sentence. If he's got 35 years to go, do we relinquish the 35-year sentence because his personal circumstances justify it? That's the issue on a compassionate.
yes, that is compassionate release, but the statute says in order to determine whether or not compassionate release should be granted, you have to weigh the 3553A factors. That is clear.
Yeah.
3553A4A1 says the court shall consider the sentencing range as set forth in the guidelines. That is a given, that you start from the correct guideline range.
Except the very next phrase, it says 3553A as applicable.
To the extent,
Yeah, to the extent applicable, but to reduce a sentence to release on time served doesn't require recalculation of the guidelines.
well, you're assuming it's time served. Compassionate release can also
Well,
just be a
compassionate
sentence
release is
reduction.
that.
They
You don't reduce the sentence and leave them in prison. The whole reason for compassionate release, these COVID cases, is because the man's exposed to serious consequences if he stays in prison.
In some
I haven't seen a
cases,
single COVID case where they say, I want my sentence cut in half.
in some cases, they're sent to home confinement, which is still
Still, I'm
Technically
telling you, he's
imprisonment.
getting out of prison.
okay. Well, in this case, he's actually 2 years away, which is why it makes a big difference. The guideline range when he came to the court was 7 years lower without the career offender enhancement. He's now 2 years away from being released. He's already completed the non-career offender guideline range, which is why the sentencing weight, the calculation that the court had to do, was so different than it had been at the original sentencing. And for the court to say, I already did this weighing, I did it 6 years ago, that doesn't satisfy what had to be done today. When you apply 3582 today, which Judge Gregory, in your concurrence in Kibble said, you have to look at facts as they exist today. You can't just rely on something that happened years before.
Exactly. That's the whole point. I mean, it's the framework of 3553 is where you start. Exactly. And you have to, when you're looking at COVID is not the only reason for extraordinary circumstance. Matter of fact, it's wide open. And the McCoy said that, where you can look at changes. So it's not recalculating, it's the point where we now know that the law has changed so that the man is sitting in prison. And if he had reduced it to the point that it went down before, he's basically served a full sentence. You could analogize that. But he did not do that. The court did not do that. They didn't look at that. It's clear from the record, the court didn't do that.
It's clear from the record, I think, that the court didn't truly accept or that the guideline range didn't apply any longer. The fact that the court said, I already did this calculation, it already weighs in favor of a 132-month sentence. We are simply asking for a remand to go back to see if the court, once it's made more clear, would say, no, now that the guideline range is, in the 70-month range versus the 188, I believe that you, having served 80-something months, has already met the factors for need to provide public safety, deter other crimes, satisfy all the
That's a
other.
good argument there, but I don't think you made any of those arguments to the district court.
I think we did. The JA pages 84 and 315 to 316. 315 is in the reply. We said that given that the co-defendant has, calculating used in calculating the career offender enhancement that the government acknowledges would
What
no
page?
longer
What-
apply.
What page?
I'm sorry, top of page 315. It was talking about the previous convictions, and it said they were used in calculating the career offender enhancement that the government acknowledges would no longer apply. And the government did state on JA 251 that the defendant's conspiracy conviction no longer qualifies as a career offender predicate.
Right. Well,
So
I don't wanna
the career
belabor that
offender-
point, But I mean, those are offered as, if you did this, this is what you would find today.
Yes.
But I'm still troubled by, you never argued to the court, this is something you're required to do. The statute requires you to do, 3553A requires you to do that. That's just an argument you didn't make.
I believe it's an argument that we made, not as artfully as we could have. But it doesn't change the duty, the court's duty, which is to correctly calculate the guideline range. I see I'm over time.
Well, the court is responsible for knowing the law.
Yes,
Once you argue the facts, I mean, you don't have to give a tutorial to the court.
yes.
Really, I think so.
I'm over time, so I will come back on rebuttal. Thank you.
Okay, thank you. Mr. Jordan?
Your Honor, may it please the court? Do I draw on behalf of the United States of America? To the
Are you
extent,
willing to remove your mask while you're talking? I'm having a hard time hearing through
I
it.
am.
I want to make sure though, are you comfortable with that?
Yes, I am.
Oh, I'm sorry. Thank you. Yes, of course.
Okay,
I appreciate that. I just forgot, Your Honor.
okay, all right. Because you had the option. I want to make that clear on the record.
I understand, Your Honor.
Okay, and with that, knowing that option, you'll take it off?
Yes, I do, Your Honor.
Okay, thank you. Go ahead.
In addressing the issue of whether the district court erred in determining whether the 3553 factors did warrant a compassionate release, the government believes that the district court's ruling should be affirmed for three reasons. First, the district court was aware of the undisputed guidelines without the career offender enhancement. Second, the district court properly considered the 3553 factors when making its determination. And third, though not dispositive, the standard of review for this issue is abuse of discretion and not de novo. So with that, I want to address the first point with regards to the district court being aware of the undisputed guidelines. The district court summarized in this opinion that the offense was based off of 201.9 grams of cocaine and that the criminal history category was 5. That's in Joint Appendix page 32. The district court also acknowledged the arguments that Mr. Jackson made about the career offender adjustment on the same page. Now, under Chavez-Meza, the district court is not required to explicitly address each argument when it considers compassionate release motions. Like in United States versus High, which this court ruled on, the district court provided significantly more than the court in Chavez-Meza. What Mr. Jackson wants here is for the district court to have written out explicitly all of the arguments it was considered, but that's simply not what the Supreme Court has said.
I didn't hear counsel say that. Counsel didn't say that he needed to write out every factor. Counsel said that he has to apply the factors that are there, which is the first one under A. In A41, it's nothing about writing them out. We know that. That's not the issue here. The fact is you have to start from the right base, don't you? The extraordinary circumstance is that he's in prison and we know the law has changed. And therefore, when you look at it in terms of the 3553 Act factors, one is you got to know where he should be now. And there's no evidence in this record that the court ever did that. And that was the issue before the court, claimed before the court. So it's not about trying to write down, this is not a Scrivener's case about writing down every factor. The fact is that is the sine qua non of the case. Two things, my medical reasons and the fact that I shouldn't be, my sentence is wrong. I'm not a career offender anymore. And that's undisputed as a matter of law. So if you started the 3553 facts, which you must under 3582 C1A, then you get to that right there. And if you said that you looked at it, since the difference between you don't have to mention what you looked at, but you do assert that you reviewed it. And there's no way to review this and come up with it's right now. It's wrong.
I understand that, Your Honor. So
Well, but let's get to that's what this case is about. It's not. She's not. Nobody arguing what you're talking about. Writing down everything he looked at.
Your Honor, with regards to the extraordinary purpose of bringing forward the compassionate release, this is unlike McCoy. In McCoy, the defendants brought forward the compassionate release on the basis of the intervening case law, saying that the statute of 924Cs was no longer appropriate. That's not what happened here. We don't have a case in which Mr. Jackson said to the district court that compassionate release is would be based off of intervening case law. The compassionate release is based off of COVID factors. The intervening case law didn't come into account in Mr. Jackson's argument until considering the 3553 factors. And I think that the distinction there is significant.
But that distinction is without a difference because the court, as you said a few seconds ago, a couple of minutes ago, he listed that as one of the factors that's before that was argued. You said that. The court acknowledged that that was separate from the medical reason for compassionate release.
Well, I think when the court acknowledged that factor, it acknowledged it in the context of 3553. The court had already.
You think that it was summarizing the arguments made before the court. That's what it was doing. It didn't say anything about really what the analysis was in the 3553. As you said, it didn't have to. But now you're trying to you can't use it as a sword and a shield. He was listing what was before the court. There were 2 points, medical and I'm no longer a career offender. The court verified, you can't change what the court said. The court said it was before it. What you don't have is any analysis as to how in the world could you look at these 3553A 4-1 and conclude that it is a correct sentence now. It is not. It is not as a matter of law. I mean, you can't, I mean, my goodness, people are in prison and they've done something wrong. At least it ought to be based on what now the law is what they should serve. That's what's compassionate about it. It's called justice.
Your Honor, the government's position is that Judge Chazanow took into account the 3553 factors and mentioned the argument about the career offender no longer being applicable in the context of discussing the 3553 factors. Judge Chazanow also mentioned that she considered many of the same factors as sentencing, but many is the key term there. It was not the exclusive consideration. Judge Chazanow also acknowledged the arguments about career offender guidelines and acknowledged the discussion about Mr. Jackson's infractions while in prison. And with all of those things combined, Judge Chazanow decided that when looking at the 3553 factors that were applicable under the Judge Chazanow's discretion, that compassionate release would not be suitable in this instance.
But what weight was given, as you ticked off, to the fact that his sentence is now wrong? What if anything? Nothing.
Your Honor, I don't think I'm in a position to say the amount of weight given. It was acknowledged.
Was it acknowledged as considered?
Yes.
Okay, well, if it's considered, then what would be the starting point of the sentence? We're looking at. Don't you have to first find out what the sentence is? So you got a reduction within a reduction. If you consider it, the 3553 gets you where it should be. Then you look at whether or not it should be reduced, if at all. But in this case, you didn't need any further reduction because basically once you did that, he's really served his time. I mean, this case is really just an incredible type of finding on this fact that you can just ignore what the man's sentence said. He's not a career offender. We know that.
Your Honor, with regards to where the judge should start off with guidelines, and the reason why I say the judge was perfectly aware of it and that was undisputed, this is different from Lancaster, which this court decided, which, by the way, is a First Step Act case and not under. That's
right. So it's the opposite here.
Right, but in the context of how the court considered the 3553 factors and the guidelines, in Lancaster, the court didn't have a basis to reconsider the guidelines once the career offender guidelines were removed because that court had never ruled upon what the appropriate drug quantity would be. That doesn't apply here. In this case, the parties did not dispute that the appropriate drug quantity and established that the offense level was 28 prior to a plea agreement, so 25 after a plea agreement. So once you combine 25 offense level and criminal history category 5, the guidelines have been calculated. The court acknowledged both of those things in its opinion. It acknowledged the guidelines, and the criminal history 5.
Wasn't he sentenced as a career offender?
Career offender is what put Mr. Jackson at a 6. So the court acknowledged the argument that without the career,
that was important, wasn't it?
5.
That was important.
Yes, Your Honor.
And that's what needs to be corrected, doesn't it, when you look at these factors? I mean, it's not rocket science. I mean, you have to do this. I mean, this is important. This involves people's lives in terms of time in prison. I mean, and the court, doesn't it, in fairness, doesn't this have to be remanded to look at that?
Your Honor, the government position that it does not. There's no requirement that the guidelines have to be recalculated. And there's an appreciable distinction between allowed and required. So under the First Step Act, it is allowed and required. But under C1A, it's just allowed. That there's nothing saying that the court cannot.
How do you square that with McCoy?
Your Honor, so in the case of McCoy, in which the basis of the compassionate release motion was intervening case law, this court decided that the court was allowed to consider that.
As this one is, it were two things. You can't get around that. It was more than just medical conditions as it relates to susceptibility to COVID. It doesn't have to be, it was two parts. Just like McCoy, that was the only one. This was one of two. How does that distinguish in counsel?
Your Honor,
how did you get from McCoy the fact that, you added the medical so that you don't have to follow McCoy? Is that logical or any kind of analysis, legal analysis? I'm just asking you, how do you square that?
Your Honor, I think you square it because the basis for the compassionate, as the government reads it, the basis for the compassionate release motion is the COVID-19 pandemic.
That was one of them.
The government position is that was the only.
How can that be your only position? The court acknowledged that he made that argument. You can't have it both ways.
Your Honor.
Wait a minute. Let's argue the basis for the relief under 3582 C1A was in a more than just his medical condition and susceptibility to COVID. Is that correct? Can we agree on that? That he raised the question about his sentence, that he's no longer a career offender. Can we agree on that? I mean, you know the cases. You mean to tell me you got to fumble through papers to find that out? I know you don't want to admit it, but you did because it's right there in the record. You can't wish away that.
So,
can I ask my question?
Yes, you should. I don't agree with that, and I would like to identify.
You said you don't agree with it?
I don't agree that Mr. Jackson proposed the intervening case law as the basis for compassionate release.
Well, what would be the basis for not being a career offender now, than other than the fact that it's now changed?
So, Your Honor,
I'm not trying to sound a trick question. If you're saying that I'm no longer a career offender, implicitly you're saying that something changed, like law.
Your Honor, the government's position is that Mr. Jackson presented no longer career offender under the 3553 factor discussion. So in JA 83, it comes under subsection C. And subsection C is titled the relevant 3553 sentencing factors warrants. And I won't read the whole title for Your Honor, but that's where the discussion comes up. And in that section is where he talks about without the career offender enhancement. And this is on page 84. Mr. Jackson's guidelines range of level 25 after deductions and so forth. It comes in the context of saying, Judge Chazanow, now that if you accept COVID-19 as a basis for the extraordinary and compelling reason, now I want you to consider the 3553 factors. And within that is when he first mentions the career offender guidelines. He does not mention it in the section prior to in which he's just trying to establish the compelling reason. That's why the government position is that though Judge Chazanow acknowledged it, she acknowledged it in the context of the 3553 factors, which is where Mr. Jackson presented it.
But it is in the context of it. I mean, when you look at the factor under 841, doesn't it talk about the guidelines? What the guidelines are now?
Yes, and that's where we get to the discussion of the discretion of the district court when it's considering the applicable 3553 factors. Judge Chazanow's discretion was that guideline was not applicable for her consideration of Mr. Jackson's motion for compassionate release.
Boy, that's not in the record. You're saying that, but it's no record that she looked at it at all. I mean, district court looked at that at all in terms of factoring for A41. Is it right?
Your Honor, I think what's in the record is that Judge Chazanel summarized what the guidelines would be and acknowledged the argument that the career offender provision would no longer apply to Mr. Jackson under the conspiracy count. So I think with that, we have more than we have in Chavez-Meza, in which the judge simply checked off boxes. We have a case here in which the judge acknowledged these would be the bases. It would be offense level 25. It would be criminal history category 5. And the argument presented is that without the career offender, this would be the basis for the guidelines. So I think we get a lot more here than we do in Chavez-Meza, similar to what we got in High, in which the court determined that that was sufficient.
Well, High is totally different, man. High wasn't dealing with a change in the law.
No, Your Honor. High was
different. That's the apples and oranges. Congress decided that this was necessary based on a lot of different things in terms of sentencing. And it was to consider reduction. Do you agree that there are no guidelines for, when I say guidelines, I should say guardrails? Under 3582 C1A, do you think the court could reduce a sentence that's a 50-year sentence and it's been only served 5 years if they found the factors to reduce it to time served?
Yes, and that's part of why recalculation of the guidelines is not necessary, because the court isn't confined to any sort of recalculation when it's making that determination.
Yeah, but it is for the purposes of, in terms of, as a sense of a rule of lenity, don't you first have to look at what's present in the state of the law and then you decide? Now, for example, if we find that the court looked at all of these things and said this and then say, whoa, I don't care if this person is in prison longer than he should be, I still won't give him any relief. That may be a different case, but you don't have that record here that happened. That's what I'm talking about. You're right, at the end of the day, maybe the court could. That's a good point. But that's a point made on the other side of recognizing what the proper sentence or guideline sentence is now. But that's not evident here. And there's no sandbagging at all because it's in the record that it was presented to the court. But I just don't see how the government makes these arguments on behalf of the United States. That, that a person ought to be in prison, notwithstanding we now know that they were sentenced wrongly.
Yeah, under Chavez-Meza, the compassionate release motions will not be a plenary resentencing. The court is not in a position where it is required to come up with a resentence, which is what you see in C1B.
This is not an imposition case, it's a reduction case.
That's exactly my point, Your Honor.
Yeah, but in the reduction, it comes first. Let's get it to the point first where it should be, and then decide whether you want to reduce it. But you can't do it if you've never looked at what's clearly before in terms of the law and the change. This is presented as a change in law. That's the only way it could be if I'm arguing that I'm no longer a career offender. I mean, what happened to the rule of lenity? My goodness, it doesn't even exist anymore. Basically, it seems like in federal jurisprudence.
Yeah, and I think we would be in a very different position if the basis for the compassionate release motion was the intervening case law and no longer career offender being applicable. I understand that Your Honor's position is that was the basis. The government contends that the 3553 factors is the only context.
So you concede then if it actually was there before the court, that would be fine.
Your Honor, I don't
just
think
said that. I think you just said that. I just thought.
No, I said that we would be in a very different position.
And the position would be what?
That when taking into account United States v. McCoy, in which the basis for compassionate release was intervening case law, the district court had a different analysis. And I think the Fourth Circuit expects a different analysis, but that's not what we have here. The basis is COVID-19. The court conceded without really considering the dynamic factors of COVID-19 that the basis had been met. It went into the discussion of 3553. So I think to the extent that the opinion of the court takes into account all of that stuff is because it was one of the 3553 factors. But I also note for the court that the court determines the the abuse of discretion as pertains to orders and not opinions. And what we have here is a situation in which Mr. Jackson was actually, unlike United States v. McCoy, in which the sentencing of stacking 924Cs could not exist when intervening case law came into play. And unlike Lancaster, in which the sentence needed to be recalculated because it was never initially calculated outside career offender, we have a case in which Mr. Jackson's, the facts that were agreed upon, there was a substance for 841A. The judge is aware of that. Significantly, as this court has noted before, is the same judge that made the initial sentence and determination, that is looking at the compassionate release motion. And that judge knows that Mr. Jackson, while the plea was to 846 and the conspiracy no longer applies for career offender, there were 3 substantive acts that could have been pled to had this intervening case law.
Your argument, you're doing just the opposite. You're saying basically did a resentence. But say, well, let's see if you do this right here, you do this, and then let's see whether it really made a difference whether he was a career offender or not. That sounds in resentencing as opposed to this is a reduction here. Reduction in terms of compassionate release, and is first consider the argument that I'm no longer a career offender. And you're saying, well, you can bypass that if you can find some way that you redo this and add it up and look at what could have been charged and what was there in terms of weight and all those things, and all the amalgam of all of that. That sounds like resentencing to me. I thought that's exactly what we were not supposed to do here. This is a reduction.
I see I'm running out of time. Can I address that question, Your Honor?
Well, go ahead, yes.
The government's position is that Judge Chazanel did properly consider the 3553 factors, and our position is that she was aware of what the guidelines would be, but significantly, she's not required to have done that. So our position is that she did it when she outlined the offense level and she outlined the criminal history category, but she did not need to do those steps because the language of C1A directly tracks C1B. So there's a discussion. Mr. Jackson wants the court to accept that C1B is actually closer to C2. That C1A is closer to C1B, but the government positions that if you look at the language of C1A and look at the language of C2 as it pertains to may reduce, it tracks the language. It doesn't have impose, as Your Honor pointed out. It says that it may reduce if the 3553 factors to the extent they are applicable. And the government position is that that is the discretion of the court.
And so applicable here because the sentence has now been reduced based on a change in law. That's why it's applicable, clearly.
And a court would be allowed to make that determination, but the discretion of the district court would allow it to say that it is not applicable for whatever reason. And that's what the district court did here. It actually acknowledged the new guidelines, but it didn't have to.
Did the court say here why that's not applicable, the reduction, that he's no longer a career offender? It did not. It did not.
I think part of why the court did not, Your Honor, because it was not in contention.
I didn't ask you why it did not. It did not. Correct?
Can we
agree on some facts, counsel? I mean, my goodness, I'm batting zero here. The court did not. Is that right? I know you don't want to say it, but the truth will set you free. I mean, right? The court did not articulate anything about why it discounted the fact that he's no longer a career offender. It did not.
Your Honor, government's position is that the court did not.
It did not, did it?
It did not.
Thank you.
If there's nothing else from the court, that the government reminds the court that it can affirm on any grounds, and unless there are no further questions, the government will submit when it's brief. I appreciate your time.
Thank you so much, Mr. Johan.
Thank you, Your Honors.
Commissioner Donning.
To clarify something that I think the government did agree in the end is that the opinion, which is on pages JA 28 through 36, there is not a statement anywhere in there that shows the court acknowledge that he's not a career offender. It's not in there. I've read it 100 times.
I know it. I was wondering why counsel was so difficult.
The court summarized each party's arguments on page JA 32. It said he argued that the prior offenses were minor. He already served it. He would have served what would have been the non-guideline range. That's not saying that he's not a career offender today. Has support, and then it said what the government argued, and then it's summarized and said the court took into consideration many of these factors at the time of the sentencing, again 2015, and nothing has changed that. The COVID didn't change that. I also want to correct, actually, to be clear, below the appellant should have argued that the change in the career offender status was itself an extraordinary and compelling circumstance, but we did not. The extraordinary and compelling circumstance argument was based on COVID and his medical vulnerability. The 3553A factors is where we argued that the fact that he was no longer a career offender dramatically changed the balancing. But I don't think it matters whether it came in the first step or the second step, because
It does, because Congress began that whole section by saying that district courts are not authorized to reduce sentences. And then it makes an exception for the only reason given in this applicable here, extraordinary and compelling circumstance. And so the question is, did the court address all the factors for considering an extraordinary and compelling circumstance? And in doing that, it is directed to consider 3553 factors. But those 3553 factors still are applicable only to the extent they inform the exception, which is extraordinary and compelling circumstance. So here the compelling circumstance is the risk of bad health under COVID. And the court's looking at that as the reason, and it has to consider 3553 considerations as applicable. And it found, it announced over a couple of pages what was applicable and decided. There's no need in that whole circumstance, either by statute or by logic, to recalculate guidelines. I mean, it's so foreign. We have other procedures for doing that. I mean, we have 2255 and all these other types of motions, Rule 35 to correct sentences, First Act. There are other places, but this exception is extraordinary and compelling circumstances based on COVID. That's the motion. And the court in doing that is entitled, not compelled, entitled to consider 3553 factors as relevant. And it did so. And it did not find it necessary to recalculate the guidelines, and there's no mandate that it had to. This would be the first case in the country that does that.
If I could just address, the first step is whether or not there are extraordinary and compelling circumstances. The court here said that it was going to assume without deciding that his health was ill enough that it would warrant reduction. Then move to step 2, 3553A.
I understand that. I mean, you want to slice it thin and precise. I'm trying to give you the big picture. In other words, it's totally irrelevant in the whole analysis to say I have to recompute the sentence when I'm exercising a very broad discretion to reduce a sentence based on compelling circumstances. And in doing that, I consider the 3553 factors. We've gone through that on a bunch of cases, McCoy and High and all these other cases that what you go through. But I'm trying to bring the issue back to what's before the court. And what's before the court is compelling extraordinary circumstances based on COVID. And the request is to get out of jail. And so now the question is, the court is in its discretion entitled to look at 3553 factors as applicable. And the court went through them and explained them in detail.
Starting from the wrong point. I mean,
it did not commit a single error. It just made those observations.
It made observations based on something that existed 6 years earlier.
Didn't find it necessary to recompute the sentence. It was assessing whether the man should stay in jail based on his conduct or whether his COVID should let him out of jail.
Right.
That's a balancing act.
But it said, I already did this balancing 6 years ago, and I'm not going to redo it.
She relied on facts about that. And the question is, I mean, the sentence was still within the guidelines. I mean, it's within the statute. I mean, it was still a statutory sentence. It wasn't a legal sentence.
But it started 7 years higher. We think it makes a difference, and it's an error. I mean, I think the government would agree that and finally did, that the court started from the wrong spot.
What was error? What did the court say in error?
The court said if he was not a career offender, this would have been his guideline range. Didn't say he is not today a career offender.
I know, but it took it into account, right?
No, actually what the court took into account was that the predicates were minor, that he had rehabilitated himself, they had community support. On the defense side, the court also considered his criminal history, the fact that he'd served half his sentence, and his infractions. That's what the court said. The court did not say, I am starting from a different point.
But you don't start in this whole calculus. That's the problem.
35
You're presuming there's a recalculation of a sentence. This is a
3553,
reduction of a sentence based on compassionate release.
yes.
Okay.
And 3553A41 says to start the analysis, you have to start from the correct guideline range.
It does not. There is nothing that directs compassionate release analysis to start with the recalculation of the guideline. And it's inconsistent with the whole task given to the court.
Respectfully, we believe that the absence of language telling the court that it can't means that it does, because
No, it says
the
it
load
may
star.
consider as it considers relevant. The court may find that a man is in very serious condition in prison. But he's being treated, it's a borderline case, but he said, this guy's a murderer. He has only served 2 years of a 30-year sentence. We understand his compassion and his personal circumstances, but we think that that does not outweigh the needs of the community to have him serve his time.
Can I
Now,
just,
that is a type of analysis that Congress envisioned. They authorized the judge to consider 3553 factors, and judges daily, we're getting these daily, these cases, are doing that. That's
we think
exactly.
it's more than authorizing because it actually directs courts to use 3553A, which the FSA does not. But let me just say, the last thing I'm going to say is the guidelines are the lodestar. The Supreme Court has said that the failure to correctly calculate a guideline range is error. It's assumed, it's
That's in
plain
sentencing.
error.
That's in sentencing. You have to be fair.
Yes,
We're
that is
talking
in
about a
sentencing.
reduction in sentence, and the Supreme Court made absolutely clear that imposing sentence is a different criteria, and Congress has different criteria than for reduction. And your argument is exactly what they rejected in Dillon.
I think it's different because we're saying,
Not different. We're under the very same arguments. You're reciting sentencing requirements to calculate a guideline correctly. That's a procedural requirement that's imposed on a court. He has to do that. And then he can make his decision on that. That is not a requirement on the function of reducing a sentence. And the court explained that and said, you have to stick with the statute, and pointed to it. But
The
the
function of
last-
reducing a sentence is to find out exactly what the sentence ought to be.
yes. And the balancing, the lodestar of the guidelines is for uniformity and proportionality. The Supreme Court said the guidelines are the lodestar and they root
where
everything.
did they say that on a compassionate release case?
No,
Of course not. That's a sentencing problem. Come on.
it is sentencing, but that tells you that 3553A, the weighing, if you start the balancing from the wrong point, the entire thing is
They're not
invalid.
balancing the point. They're not resentencing. They're not
It's-
determining a new sentence. They're basically saying, should we relieve this man of the sentence that was imposed?
And relieving him considers whether or not other people like him being
No.
sentenced would already be home. And that is a part of the
That is not a
3553A
part.
factor.
And you can't point to any part that a judge has to do. I mean, I understand your argument. You'd just love to have this whole thing be resentenced.
No,
And you had all kinds of mechanisms to correct it if it's wrong. But the compassionate release motion is just what it says. The court needs to find extraordinary and compelling circumstances, and in doing so, it may weigh the factors under 3553.
if we could just go back to the court and see if the court would come to a different weighing based on the correct range, that's all we're asking for. We're not asking for a resentencing. We're just asking for the court to get it, the starting point right. If the factors weigh out the same, then we're done.
Now, in these compassionate release cases, there are multiple factors under 3553A. I don't know how many there are if you list them. We're going to say if you don't go down and tick through every
No,
one of those,
not tick through anything. Start from the correct range, period.
The truth of the matter is, the courts usually look at the sufficiency of the sentence and whether society still needs his incarceration and factors of safety of the community, that type of thing.
And all of
Because what
those,
they're doing is they're overriding a sentence that had already been entered.
which today would not have been entered. That's sort of the critical point. Okay, thank you.
Thank you both for your arguments. We can't come down. Cases submit, yeah. Thank you. We can't come down to greet you as we'd like to do it in a normal fashion, but please know we appreciate your arguments, both of you. Acquitted yourself very well on behalf of your client and on behalf of the United States. And I wish you well and be safe. Thank you.
Thank you.
Mr. Howell, you ready?
Thank you, Your Honors. Sorry, the mask is something. Your Honors, why isn't, I began to ask, why isn't this case governed by Trust Guard versus Collins? Why wasn't the district court correct in basically saying, both in terms of justiciability concerns, both in as well as in terms of intent, would be something that would be determined in the state court? No need to determine it right now, and it would be something that would be an interference, as in Trust Guard, with a fact that would be determined as to evidence in a medical malpractice case and done without the same panoply of evidence that would be before the district court. Why isn't that proper? Trust Guard, since it was issued, that decision has basically governed decisions regarding insurance declaratory judgment actions over and over. And with respect to that case, typically the first analysis is whether or not there is a immediate or realistic present justiciable controversy. And in the case of insurance company duty to defend cases as well as indemnity cases, typically that's determined to be a present issue of controversy and a present injury. But there's something else in this case that also had nothing to do, if you will, with how the state court case would be determined, which is that this was a collateral indemnity duty case, if you will. Just as the Nautilus Insurance Company versus Winchester Homes was a misrepresentation case, just as Great American Insurance Company versus Gross was a.
But there was no bar to have you bringing a declaratory judgment action in the state court.
I'm sorry, Your Honor, there was no bar.
If you had wanted to bring the same action in the state court, you could have done so.
Well, we could have brought it in that form. Absolutely, Your Honor is correct. We could have brought it, and we would have brought it obviously in the same timing that we did in federal court. There is a body of instructive evidence that the Fourth Circuit has issued over the years since the original cases in interpreting Brillhart that encourages insurance companies to come to the district courts to seek early determinations of coverage and defense because of a couple of important reasons. One is that the insurance company from the get-go has an immediate duty of settlement. If the insurance company receives a limits demand, not knowing whether there is coverage means the insurance company has to guess about whether it's right. If it guesses wrong, the consequences are considerable. But in addition, it is essential for all of the parties to have some notion of whether there's coverage or not. In the absence, everyone is guessing. And certainly, as in Trust Guard, if we are really talking about a core issue that's going to be determined at the state court trial, in that case, it was whether or not there was agency, and that absolutely kicked out or kept in one of the parties. If that's the case, then indemnity really waits until the trial court it determines the outcome of that case, or the jury does. This is not that sort of case. This is the sort of case that in Great American, there is a separate question of a violation that essentially voids recovery under the policy. In that case was whether Mr. Ken Patterson properly, truthfully said that the financial statements in support of an extra $10 million of coverage were true. And that, yes, Your Honor.
If the alteration made the medical record more correct, that still voids the policy?
This is the way the law addresses that question in Virginia. The alteration, if it's a breach of a duty of cooperation, has to be material. If it's trivial, if it has no impact, there is no way it is a breach of the duty of cooperation. The policy doesn't have to say that. The law says that. And in this context, material would mean
we have no idea, based on what the limited record we have, what the alteration you claim is to be.
That's right, Your Honor. With respect to, frankly, patient confidentiality issues, we allege the sufficient facts under the language of the policy that there was a material alteration, that it involved potential evidence with respect to patient care, and that's all the policy requires. But the law adds, again, an overlay. That has to be material. We alleged it was material. Yes, Your Honor.
I suppose if the alterations were not material or wouldn't affect the risk of the insurance company, then you would, the declaratory judgment would provide you have coverage. That would be done by the court exercising jurisdiction. I think your argument, I suppose, rests on the notion that there is an allegation that there was a material alteration that alters the risk of the company. And you have to make that demonstration. But the real question is, can that be determined in advance of the trial in order to determine who defends a trial?
All right, Your Honor. Materiality with respect to insurance law in this case has to do with whether or not it affects the insurance company's ability to fulfill its duties. That includes investigation of the claim.
I understand all that, but that's not the issue before us. In other words, we're not trying the case or whether you've set a good ground. What we're deciding is whether the declaratory judgment is available or should be available in advance of the state trial or while the state trial is going on in order to order the who defends. And if you fail in determining on the substance that the change was material, you're going to cover. And if you succeed, you're not going to have to cover. But that's a Virginia law, and that's not before us, is it?
In our case, materiality has nothing whatsoever to do.
Well, I'm not arguing whether it's material. I'm arguing whether it changed the risk or whatever the standard is. The fact is you have asserted a condition in the policy that would entitle you not to cover. But we're not here to decide whether you have adequately proved that. That has to be done in the proceeding. And the insured can come back and say, I made changes that were beneficial, that corrected things, that and you're going to lose. You're going to have to provide coverage. But the whole issue here is whether this proceeding it should go ahead now in this context. And I think our law basically is to focus on the Nautilus standards issues that we issued, Judge Phillips issued years ago here. And it seems to me you have to accept whatever the declaratory judgment says if it can go ahead.
Your Honor, we would have the same issue to adjudicate after the state court trial as before, and nothing that would be offered in the state court trial would have to do with the insurance companies.
That goes to the Nautilus factors. In other words, the question is, will the state proceeding decide the same issues? Are the same parties? Is there a real dispute here? Those types of things. I mean, we have jurisdiction under what is this, diversity?
Well,
there's no jurisdiction under 2201.
No, there's not, Your Honor.
Okay, so that's the remedy that's available in federal court. But what's your basis for jurisdiction here?
In this case, it is the exercise of discretion to entertain.
I'm asking you what the jurisdictional basis for this action is.
Well, I'm sorry. Well, we have diversity as a reason.
Okay, that's what I thought it was. Okay.
I'm sorry, Your Honor. Again, my mistake for not understanding. I apologize. We'd have the same issue to adjudicate.
What happens?
I'm sorry, Your Honor.
What happens in this case? Let's say we tell the district court they were wrong. They go forward, and there's evidence presented that the physician defendant made a material change that falsified the medical record. And that's the evidence that's introduced in the federal declaratory judgment action. And the findings made on that. Isn't there going to be a collateral estoppel issue that would then come up in the state trial?
There's going to be no determination in federal court that any alteration had any relevance to the medical malpractice case. There's not going to be any dispute about what the alterations were. The only issue, and it's an issue that only the insurance company can offer evidence to, and we're not a party below, is what is the impact on our job, on our duties? Does it make any difference? If it doesn't, we're out of court. If it does, that has no bearing on the underlying state court trial.
You're going to have to produce some evidence as to what the alteration was. All we have now is a bare allegation that some sort of unknown alteration occurred, correct?
Yes, absolutely right, Your Honor. The actual alterations would be in evidence in this case, in the state court case, and the confusion.
Well, but that goes back to my question. If it proceeds here and there's a finding made that alterations A, B, and C were made, isn't there going to be a collateral estoppel effect in the state trial?
Well, there's going to be a determination that the record as it was changed existed. That doesn't mean that there's a determination as to whether or not there is liability or basis for medical malpractice. The state court complaint doesn't even allege that. And it's unlikely that this would ever come into evidence in the state court.
Well, why do you say that? I mean, if there's an alteration of the record that shows that the defendant physician in this case and in that case changed something that from true to false, that would seem to be a fairly material change for both the insurance aspect and the liability aspect in the state court.
Well, it wouldn't affect the insurance issue with respect to materiality, but Your Honor, it's anathema to offer that evidence in the state court. It is anathema to offer that evidence in the state court trial because of its impact on coverage. It is speculation that it might even come in. And what we said in Great American Insurance Company, what the court said was, we're not speculating. We're doing a careful examination of the scope, and we're determining whether we have a significant overlay of duplicative issues. Great American had more duplicative issues on which liability turned than any other case ever involving declaratory judgment, ever. The state court case in Alabama absolutely addressed that issue, but this court said that wasn't all it did, and it wasn't a significant overlay. The overlay with respect to this case is a speculation that there might be an introduction of evidence with respect to what records were changed. The district court thought that meant that's an evidentiary determination of materiality. It's not. Materiality in the insurance case has nothing to do with admissibility below. And admissibility below, if it's introduced, there's no dispute to what happened. There's no dispute to what happened. The change either is or isn't something that fits within the requirements of the policy, just as a misrepresentation in the Great American case fit in with something that absolutely was coming into evidence in that case. But there were so many, fundamentally, the Reciprocal of America case was about something else. It was about a scheme to mask retrocessionaire reinsurance. And this court apprehended that was very different from the issue that, yes, would or might well be litigated as part of that, lying about financial statements to the regulators. It recognized that. But it said under the precedent we apply, it has to be more than that. And we have a duty to inquire carefully into that. And at the end of the day, even if we see that this is something that could, in fact, impact, and goodness knows we argued that our experts wouldn't be in that case in federal court. There wouldn't be the opportunity to have a full panoply of the evidence. But it only went to a piece of a larger case. And that's why the Court of Appeals determined that it was an abuse of discretion not to entertain the case. Your Honor, with respect to, again, the issue of what the district court was doing, even though I don't know that it articulated that well, I do think that it was focusing on, in addition, the concerns in Trust Guard about why do we have to do this now? Why do we have to make this determination now? Won't the state court make this determination? Well, of course it won't. We're not a party. And because necessary facts to establish our position will not be determined by the state court, we'll have this case at the end of the day. But it shouldn't be at the end of the day because we have immediate issues to address that affect the rights of everyone in this case. And in addition, would obviously give assistance to everyone with respect to what individuals, parties below decide to do. We've seen breach of duties of cooperation as collateral issues, even though there may be some factual overlap. For instance, one of the major Supreme Court cases involving breach of the duty was assertion of a Fifth Amendment privilege. there's not going to be any testimony about fundamental issues at stake in the state court. That certainly impacts what's going to happen in the state court. But it was a breach of cooperation as soon as it happened, as soon as the Fifth Amendment privilege was asserted, because at that point, the insurance company could no longer do its job of preparing for that state court trial. That's the difference in the focus with respect to what this particular provision involves, this type of duty involves, and what the decision would be from the state court as to should we admit as relevant evidence of changes in the record. They may or may not be relevant, but that relevance has nothing to do with our case. And because it doesn't have anything to do with our case, and again, Great American recognized this, it specifically underlined that when we are talking about a lie to an insurance company, even though there's factual overlap, that is a fundamentally different issue than what is at issue in the state court. Whether we're talking about cooperation under a policy provision, that is a fundamentally different issue. And I see that my time initially reserved is out of time, Your Honor. Thank you very much.
Thank you, Mr. Howell. Mr. McNew?
Good morning, Your Honors, and may it please the court. I'm Kyle McNew, and along with my partner, we represent the Yan estate. We're here arguing on behalf of both the Yan estate and Dr. Latawa, the appellees in this case. MedMutual's request for a declaratory judgment would have required the district court to wade into contested and undeveloped factual issues that are at issue in the underlying state court case to answer an important and novel question of state law. Its exercise of discretion to decline declaratory judgment jurisdiction was appropriate in this case. I'm going to begin with a couple of arguments.
I'm not sure that's the standard, but the question really is how you're asking the insurance company to put up a defense based on a asserted statement by the insurance company that said you haven't satisfied the conditions for a defense. And they're seeking a declaratory judgment, which is done hundreds of times. I mean, this is the standard procedure. I probably participated in 25 or 30 of these when I was a lawyer. It's just the normal way to go when there's a doubt about coverage. And the main reasons that we abstain, it's an exception to our duty to hear cases, are set forth in Nautilus. And I haven't heard much reason. The Nautilus focuses on the most significant cases where you're going to try the opposite side of the state case in federal court. So in state court, you sue the insurance company for breach of contract. They didn't do something. And in federal court, they file a reverse suit saying, we want a declaratory judgment. In that case, the federal court clearly would be asked to abstain in favor of the state court because it's a state court issued breach of contract case and so forth. But here, it's the typical case where you have a tort action and you have an insurance company being asked to provide coverage. And the issues decided in the federal court are not who's liable in the tort action. It's what does the policy provide? Now, the mere fact that there's an overlapping issue has never precluded this. Obviously, if the federal case is going to decide liability, then you may bring in the notion that they have two suits. But I haven't seen shouldn't the argument focus on the Nautilus factors?
Absolutely, Your Honor.
Okay, that's what I thought.
So I'll agree with half of what you said and disagree with the other.
Well, I would think so.
I'll agree that this is not your normal procedural fencing case. This isn't a.
But that's what the Nautilus factors are aimed at. In other words,
it's what one of the Nautilus.
Abstention is a pretty serious a matter. In other words, courts are there available to the public, and we usually address cases that are filed. So if we're abstaining from deciding a question over which we have jurisdiction, there has to be a good reason. And as you say, fencing, I think, is the typical model that I think Nautilus aims at.
Well, so yes, abstention generally is the rare bird. And that's under the Colorado River analysis. But in the Declaratory Judgment Act, because it is discretionary jurisdiction, that presumption of retaining jurisdiction isn't necessarily as strong. But I'll meet you where you are on this, right? Yes, the procedural fencing is one of the 4 Nautilus factors. And we don't have that in this case, no question. The other Nautilus factors are the state interest, efficiency, and the risk of entanglement. And so where I'm going to push back on what Your Honor said earlier is this is not your typical, I agree, these.
This is about as typical as we see them. I can't figure out, in other words, an insurance company trying to clarify its coverage before the court trial on the tort case. The insurance company gets to decide how to defend the court case on the strategies, on the evidence, on a lawyer, all kinds of things. And to make them defend a case where there is no coverage, that's their allegation, of course, but where there's no coverage, is resolved usually by the paradigm that we have here, where you have declaratory judgment and state tort action.
Sure,
and I don't know what your objection to being is to have coverage decided in this case. It's basically, it sounds to me they have an uphill battle because there's so many reasons for fixing records, adjusting records, modifying them, and so forth. If there's actual manipulation that's serious enough to cause a contract to be voided, that's a heavy burden. But I don't know why you wouldn't just, you're going to have to face off on this sooner or later, right?
So if I can take a couple pieces of that. So this is not your typical coverage dispute case because I'll answer that. Because the typical one is like my friend said, where it's a collateral issue. Was there fraud in obtaining the policy? Like, did you tell the carrier that, oh yeah, you have a 17-year-old driver living with you? That has nothing to do with with anything in the underlying case.
What if they a typical one is when they fail, when the insured fails to give notice of the claim?
Right. Now, and that has nothing to do with anything in the underlying case.
No, but it affects the way you defend the case. In other words, now you have to set aside default judgments, or you have to, or witnesses are gone. You don't have, you can't take statements and so forth. The insurance company has a risk that they sign on for. And one of the aspects of the risk is that you're going to cooperate, that the insurance is going to not destroy evidence, that it's not going to alter the case. And so it's a pretty heavy burden to get over that. But if they make that allegation, it seemed to me that ought to be tried. That's collateral. It's not going to decide the malpractice.
No, but getting to Judge Agee's question, it could impact how the malpractice case is tried.
Well, maybe.
But because yeah, I think my friend even agrees that if the answer to Judge Agee's question of if it's true that the alteration just made the record more clear, more accurate, better, that would not be a substantial, even under their paradigm that the analysis is it's substantial and material, that would not be a material thing because it wouldn't affect their ability to defend, settle, and resolve the case. But if not, right? For them to win, I think they're going to have to, even under their paradigm, they're going to have to show, and the district court is going to have to find that the point of this alteration was nefarious, or that its effect was in some way problematic to the records, kind of tantamount to spoliation.
Law on this, but my guess is that it has to be sufficiently nefarious is an okay word, manipulative, fraudulent, in order to alter the risk so that it's beyond its risk now. It can't defend it. But that's a heavy burden. That's not the issue before us. The question is, should we decide that now in advance of the state trial to decide who's going to defend that case?
And so I think that is the issue before the court, or that certainly is going to be the issue before the district court. The district court is sitting.
Oh, of course, the district court has to just look at those records to see whether they're altered and whether it affects the insurance policy.
But in determining whether to retain jurisdiction,
jurisdictions here under 1332,
right,
and the remedy is 2201.
In determining whether to exercise its declaratory judgment discretion to retain jurisdiction of the case, it has to sort of make a prediction about what's going to happen down the road. And what it's looking at is, if I get into this case.
Why does it have to do that at all?
Because
Suppose there's a malpractice case, the allegations in the malpractice are laid out. The allegation is that the insured altered the records or destroyed records. So the question is, what records and how did they do it? And there's a legal conclusion. Does that affect the contract? Does that affect the duties and the risks?
For my friend to win in the district court, the district judge is going to have to find as a fact, in order to find that this alteration was substantial and material, the district judge is going to have to find as a fact that the point of the alteration was nefarious, fraudulent, whatever, right? For me to win, that's different. But for him to win, for them to prevail, for them to get out of their coverage obligations, which is what the district judge is being asked to do right now, the judge is going to have to make that finding. That is a finding of fact that's going to put its thumb on the underlying litigation. There is a risk of
What's wrong with that? I don't understand what, if you have a big entanglement, it's one thing. But if you have a finding that there was a fraudulent alteration of a document, I don't understand why you're afraid of that. That's either going to be a fact or it's not going to be a fact. The conclusion, the legal conclusion following it is the extent to which it affects the contract.
But under the Nautilus factors, the third factor is the risk of entanglement.
Yeah,
and that fact finding is going to be a huge thumb on the scale in the underlying malpractice case, because now you have a federal district judge who has made a finding of fact that this doctor is nefarious and was trying to hide something. And I'm a party to that case, the plaintiff in the underlying malpractice claim. Dr. Littau is a party to that case, to this case, and also in the underlying case. I think we're going to be bound by that. I think that is a collateral estoppel issue. And there are two other doctors in that case.
But is there a problem with that? I mean, my point is the malpractice is another case. And if they had to decide whether you or your client was liable, that's a different story, because now you have the fencing problem. You have a federal court against a state court deciding the core issue. But this peripheral issue about whether some documents were destroyed, if they were destroyed, they can either prove it again or they can rely on what was decided. But they may not even be able to do that because not all parties are here. But that's an evidentiary hearing. I mean, you have that problem in every declaratory judgment case, virtually.
I don't believe so, because in most DEC actions, and I've been in plenty of them as well, Your Honor, and they're a useful vehicle in the right case, because in most DEC actions, the issue is so collateral to anything that, did you give timely notice? That has nothing to do with any of the facts in issue or any of the questions in issue in the underlying case. Here, did you make a material and substantial alteration to this patient's medical records? Is absolutely at issue in the underlying case. So I disagree with your premise. I disagree.
Malpractice case, it may help proof, but it's not the core of the malpractice at all. The malpractice related to the treatment of a condition.
Right. But I don't think that just, resolving the whole, answering the whole question in the underlying case is not what the Nautilus factor is. It's a risk of entanglement. If that were true, then we wouldn't have the Nautilus factors. We would just have the Nautilus factor. And that would be the procedural fencing piece. But we have all these other factors. And so, and that's what this court did in Trust Guard, right? Trust Guard, part one of Trust Guard is the Article 3 concerns. We don't have those here, no question. Part two of Trust Guard is the Nautilus factors analysis. And it didn't talk about, this is going to decide the case. This is going, it said we should abstain. The district court should have stayed its hand because it could have an impact on the underlying litigation. That's what the district, we should step back from this and let the underlying litigation play out.
I think that's the strongest argument that the district court looking at it thought it was a place of caution, right? Because the Supreme Court has said that declaratory judgment doesn't confer a right. It confers discretion on the court, but not a right to the party to have it.
Absolutely. I think the district court looked at what was alleged, right? Which wasn't much. And the district court commented on that in the oral argument multiple times. How do I decide? How am I comfortable based on what you've alleged and what you've provided me at this point that I'm not going to be sticking?
The answer, not the answer, but reflecting Judge Nehemiah's good question about why do you care or what difference does it make here? Because it could be tangential to the point where it might deal with something that comes up related to something that might be related to the insurance company, but it has nothing to do with the case. But then that might be sort of burlesque in the case and make the trial of fact feel untoward about your client or client that has nothing to do with the case. So I think the district court is looking at, why should I entangle myself with the potential?
Absolutely. I mean, it's a district judge making fact findings about the circumstances and the effect of this alteration. There's a really strong chance that it's going to come up in the circuit court. I don't know how that's going to be, whether the plaintiff is going to use it offensively, whether Dr. Latawa is going to use it defensively, whether one of the other two doctors who are at issue in the underlying case are going to use that to point the finger at Dr. Latawa. And the district judge went through that. He said, based on what you've alleged, which they've admitted isn't much, in which they said in the district court, that's their fault. That's Joint Appendix 91 to 92. They conceded the reason that there's not much in this complaint is on them. And this issue of, well, we did it to protect confidentiality. There's an easy way around that. If you think that's the cure, Judge, can we file a complaint under seal so we can tell you everything, we can give you all the skinny on this? They didn't ask to do that. They gave the district judge a very bare record, and the district judge said, I see in the exercise of discretion a decent chance, a strong chance that I'm going to stick my nose somewhere where it shouldn't be. I'm going to stay my hand. There's nothing that prevents them from coming back after the case and resolving and dealing with that then. So I don't think they should get the benefit of that. So Judge Hudson knows what he's doing. This idea that he was just confused about what a malpractice case is. That's not what he was talking about. He was saying their argument, if accepted, is going to have a pretty strong impact on the whole medical malpractice regime in Virginia. Because if, as Judge Agee said, if any alteration kicks coverage, whoo boy, there's a lot of doctors that may change how they practice medicine to the detriment of their patients. So that is a pretty big issue, and that's the state interest piece of the Nautilus factors. That's not the dispositive one, but it's one. It's one that the district court, in its discretion, found weighed in favor of staying its hand. If that had been the only one, we may have a different issue, because that issue is still going to be in play on the back end. But then it's just it's just an eerie analysis at that point. Should I answer a question of state law, or should I certify it to the Supreme Court of Virginia or something like that? Here, we have these other issues, the efficiency and entanglement issues that the district court looked at and analyzed and said there is a real risk of unnecessary entanglement. And again, this court, even in Trust Guard said, the Nautilus factors look at issues of practicality. And one of the issues of practicality is, I understand that the insurance company doesn't want to pay one more dime than it has to defend an insurer that it thinks it shouldn't have to defend it. I understand that. But there's also, that doesn't outweigh other issues, the entanglement issues, the comedy issues. Another issue of practicality as we sit here today is that the state court trial's in like 2.5 months, right? The trial is set to go forward in June in Petersburg. So after that's over, now we're going to know what role did this alteration play in the underlying case. Did it affect did it prejudice the carrier or the insured? You're going to have a much more fixed, crystallized, factual predicate from which the district court or any state, if they want to file in state court, if they want to file in federal court, can then say, all right, now I'm just answering a legal question. That's what deck actions usually are, just answering a legal question. What does the policy say? Does this stipulated set of facts implicate the policy or not? As we sit here today, it's not just a legal question. There's a factual predicate question as to what was the nature of the allegation, what was the alteration, what was its impact, why was it done, what was the motive behind it.
Didn't I hear you correctly? You said this was a novel issue?
Yes, this exclusion that they rely upon not only has never been enforced in Virginia, from what I can tell, they haven't cited a single case where across the country they've said, yes, we're going to rely on this exclusion. And so there is a novel question. Is this a condition precedent? They say it is because they say it's a cooperation clause. We say no, because a cooperation clause requires you to do something. A condition precedent under Virginia law requires you to do something, give timely notice, cooperate. Here, they exclude.
I'm not sure how this bears on it, but what if we have an insured that is also exposed potentially to some criminal liability, and the insured decides to throw out all the documents, destroy them all, everything, and the insurance company is asked to defend the civil suit? Would it be entitled to, under this clause, exclude itself from coverage? I mean, it seems to me you can concoct circumstances where it seems to me that when an insured makes it very hard for the insurance company to defend, or impossible, or likely to increase its indemnity risk, that it could invoke it. I don't think that's before us. All we have is the allegation.
Right. So I'll answer that question in two parts, if I may. I see my time's expired. I'll answer that question in two parts. One, at that far end of the spectrum.
I was trying to create.
You're taking it to the extreme. I understand that, because you could take it to the other extreme, right? Where the only alleged alteration is they change the page number, but taking it to the took it outside, put it in the trash can, and lit it on fire example. What I think most carriers there would do would say, I clearly don't have to defend you here. I'm not providing you a defense. I'm out. Come after me if you want to. That's what my experience is. They wouldn't even.
That just flips the order. The whole idea of the declaratory judgment is not to force that hand.
Right. And so, but I'm just saying, practically speaking, my experience has been in those crazy extreme cases, they don't defend under a reservation. Second, the second part of the answer is, I think the answer is maybe yes, if that is alleged, if it's alleged that is so extreme in the deck action, that's going to give the district court much more comfort at the outset that, no, I'm not going to have to be making any real contested, fact findings about what happened here or why. There's no good reason to light everything on fire, to light the records on fire. There's no, there's no chance in which that wouldn't be substantial and material. Here, they haven't given the district court or this court still today any comfort level, any meat on the bones of what these alterations were, why they were made.
Does that go, though, to the merits of the declaratory? In other words, we don't have to forecast how good their evidence is. It seems to me the question is whether this is an issue that could be decided ahead of the trial without much entanglement, the degree of entanglement. And that's, I think, your best argument, the entanglement argument.
Yeah. And the district court has to prognosticate that, because it acts at the beginning of the case before it takes evidence, before it does that discovery. Am I likely to get halfway down the road and realize I've made a mistake? and realize I'm too far in the weeds on this. So it's that risk of entanglement that is at issue here, and that the district court, well experienced, knows the law on this issue, knows that, isn't afraid of issuing declaratory judgments in the right case, said there's too big of a risk in that case, in this case, under these particular facts. This is not a case for all seasons, right? This is not you may never file a deck action on a coverage question. It's under the facts of this particular case, in light of this particular exclusion or policy provision that they rely upon. The wise course here is to stay our hand. That is a perfectly valid exercise of discretion. That's what the Supreme Court has said you should do. We would ask that the district court be affirmed.
Thank you, Mr. McNew. Mr. Howell, you have some time.
Thank you, Your Honor. It's certainly not before the court of the full knowledge of the parties in the state court case about what the changes were, but it is relevant that there is no allegation in the state court case that there is any record alteration. I suppose it could happen.
There's none now, but
there's none now, and it could happen. Judge, you're absolutely right. It could happen.
Why don't you address that issue? I think it's a substantial issue under Nautilus, the degree of entanglement from the specifics of this case. What's your response to that?
Well, Your Honor, again, first, the requirement is to make that careful inquiry as to what impact will come up. And it's not speculation. It's a determination of what there will be. Judge Spencer in the Gross case went ad nauseum in that case about what was really going to happen in the state court. Those were serious issues. In this case, I've just heard argument that plaintiff doesn't even anticipate they will offer that evidence. Maybe a co-defendant will offer it. Maybe it won't come in. We don't know. But what will
you
impact?
have the burden of proving modification, alteration, or destruction, whatever the language is of the policy. You have the burden of proving that. Let's assume you prove it in spades. You prove that there was a fraudulent alteration of documents that could be changed, and half the documents were destroyed that had relevant material on them. And the question now is, how do you think that might be used in the medical malpractice case in the state court?
Your Honor, it would be absolutely contrary to the requirements under Virginia law for us to prove fraudulent intent. That's not alleged. It would never be alleged under the terms of this policy.
It's my hypothetical. Let's just run with me. I'm trying to find out the influence. I'm trying to give you an extreme example of a hypothetical where the documents are found to be totally mistreated. My question is, the court finds that and gives you some relief. Now, what happens in the trial, the medical malpractice trial, with that finding?
Medical malpractice trial has to do with whether or not it impacts the duty of care. Ellie said in the brief that there is no basis for malpractice by virtue of record destruction. Cause of action spoke.
You know, your imagination doesn't have to go too far. The idea is a doctor creates malpractice and then he covers up. And that's perfectly legitimate evidence to go in and to help the malpractice case, isn't it, that he covered up?
If it makes no difference whether it was alleged, then Your Honor is right. Let me posit one thing.
It's a proof. You're trying to demonstrate negligence. You're trying to demonstrate a doctor failed to abide by the standards of the doctors in the community. And the part of the proof is the doctor realized this and altered or destroyed records. Would that come into evidence?
Your Honor, with respect, I would never seek to establish negligence in this type of case. It would be improper.
I didn't ask you whether you do that. I'm asking whether that evidence would be useful in the medical malpractice case.
Your Honor, I have no idea. I have no idea because I'm not there. Let me posit one thing if I could. I have a dog bite case. Simple. A dog bit. There was negligence in handling whatever they had to do with the dog. The fact of the dog biting is important. The homeowner's policy excludes bites by Rottweilers. They've got to prove there was a bite. They have to prove circumstances relating to the bite. But it's just what type of dog it was and whether it bit. It's not a substantial overlap, and we can't, I would posit, we cannot.
In that example, you know a lot more than the district court or we do at this stage. the district court had the forecast what might be with a very bare record, which it was your burden to provide. And we're in no better position than the district court.
Your Honor, the policy doesn't require us to go beyond what we alleged. It doesn't.
I'm sorry, I couldn't hear you.
The policy does not require us to go beyond what we alleged. A medical incident is just any act with respect to patient treatment. And the alteration is just something with respect to.
If the alteration is a page number, that's sufficient under your theory.
It's sufficient if it's material, if it impacts our duties. Nothing impacts our duties more than finding out that the doctor has altered records and we have to defend that case.
So the doctor put in the record initially 46 years old, patient. Doctor learns later from the daughter that only 41 years old. So the doctor goes back and crosses out 46 or erases 46, puts in 41. You argue that that's a change in the policy, a change in the records, and that authorizes a non-coverage?
No, Your Honor, it doesn't sound material to me. Not under Virginia law. There's all kinds of breaches of duties under the policies that are not material. That's why we have rescission cases to determine whether or not it made any difference to the insurance company. I can lie straight out on my application that if the company wouldn't have done anything different, they can't take my insurance away. In this case, there's going to have to be a showing as whether it made any difference in our ability to defend a doctor that the doctor had allegedly altered records in a material way.
The problem with the disconnect is your response to Judge Agee's question. He said, wasn't it your burden to put that before the district court? And your response was, almost paraphrasing it was, we don't have to do that under our contract, but you may have to do more in order to come here and say there was abuse of discretion not to get something that you had no right to. That is the declaratory judgment.
I must not have been clear. I meant we had no burden to establish fraud and that it would be contrary for Virginia law to us to try.
But you said we don't have to do it under the contract. Whatever provision you're talking about, and we're sort of, and that there's a veil between us and the facts here, which you have every right to be coy about, but there's a price perhaps of your being coy about what it is, because otherwise we have to find that the court made an error of, a fact. It is de novo, but with nautilus issues, but it's hard to say what the district court did as a matter of law that was wrong, considering those factors.
I'm sorry if it appears coy. It certainly wasn't meant to. Everybody knows what it was.
Pejorative. I meant coy in terms of a strategy. And lawyers have strategies. There's nothing wrong with you. You have to apologize for that, but coy, I think, is a good adjective for it.
Your Honor, I don't know what to say other than the language of the policy seems sufficient to me for the allegations. If we faced a motion, we faced a motion. I know what we would allege. They do too, about these record alterations. It's not before this court. My time is up, and I'm very grateful for the attention of the court today.
Thank you, Mr. Howell, and as well as Mr. McNew, for your arguments. We'd love to come down and greet you as we do in our normal Fourth Circuit fashion. I think you can understand under these circumstances we can't, but please know, nonetheless, we appreciate your arguments and your presence here today. Thank you so much, and be safe and stay well. Mr. Griffin, when you're ready.
Yes, Your Honor.
May it please the court. The question before this court is whether a case becomes moot when a regulatory agency vacates its decision to expel an entity from a program based upon a rules violation after the entity brings suit to challenge the agency's interpretation and application of those rules.
So what's the basis for our subject matter jurisdiction?
Well, there's a federal question under the Declaratory Judgment Act. There's a federal question as to what the rules are under the federal 340B program. And that really is at the heart of the controversy, Your Honor.
So tell us why that's a federal question. I thought the only allegation of subject matter jurisdiction here was that there was a final agency action under the APA.
There, in the original petition, that is correct. We challenged the action, final agency action, and it was more or less based upon the fact that agency did not give us a hearing. In the amended petition, we included the Declaratory Judgment Act as an additional basis for jurisdiction. The federal question is interpretation of 340B statute and explicitly, and particularly the anti-diversion provisions under that act. That's the federal question. And how that is being.
You say that's separate from the APA?
Yes, Your Honor. That's.
And tell us again where exactly you raised that.
Well, Your Honor, we raised it in the amended petition in paragraphs 27 through 38 of the amended petition. It spells out this controversy over the interpretation of the definition of patient, Your Honor, and then also paragraph 66 and 67 of the amended petition, where we asked for declaratory judgment, and all that is located in the record under the appendix at page 120. And we specifically cite declaratory judgment concerning plain language of the statute, and on paragraph 67, we asked for declaratory judgment, requesting that the court declare the person's interpretation of that statute unlawful and unenforceable. And Your Honor, record of page 100, we also allege that the action arises under APA and also under the Public Health Services Act and the Fifth Amendment to the United States Constitution. We don't specifically cite the Declaratory Judgment Act in the jurisdictional statement, but we do raise it as a federal question. And paragraph 7, we cite 28 USC 1331, which is federal question statute.
Did you ever tie any of that to a waiver of sovereign immunity?
No, Your Honor, we've not received a defense of sovereign immunity as an affirmative defense. And in this case, I don't know that there is sovereign immunity in this declaratory judgment action with regard to interpretation of a statute with, agency enforcement of a statute against Genesis, a covered entity under the 340B program. We're not seeking money damages. We're seeking a declaratory judgment so that we can conform our behavior in compliance with whatever the statute means. And Genesis is actually, they're in between a rock and a hard place. The statute says one thing. It says a covered entity under 340B, which Genesis is, shall not resell or transfer any drugs to anyone who's not a patient of the covered entity. Genesis interprets patient to be its patients. HRSA under 340B interprets that provision as it only applies to certain patients of Genesis. And those patients that it applies to are only those individuals who received a healthcare service from a Genesis physician and received a prescription for that service. And they would exclude from the definition of patient anyone who went to a specialist that wasn't referred directly by Genesis and received a prescription from the specialist. And the real bind that Genesis is in because of this is, as an FQHC, Federally Qualified Healthcare Center, in which they get federal funding for their mission to provide healthcare in medically underserved areas and for the poor. They are required, if a patient is at the 200% poverty level or below, to give them a sliding scale discount. If they're 100% of poverty level, Genesis is required to give them free health care. Well, the specialty drugs that are prescribed by specialists are the most expensive drugs. Yet those patients who are at that poverty level are going to come back to Genesis to fill that prescription because they know that Genesis will not charge them and cannot charge them. Yet HRSA says you can't use.
There could be a dilemma for somebody that's situated like your client. But as I understand the record, the federal agency applied that rule to your client. And then they said, well, we're taking it all back. And they voided all the actions that they had taken against you. So as of now, there is no application of this regulation or interpretation by the agency to your client. Is that correct?
There's no formal finding of an application, but Genesis is required every year to submit a certification to HRSA that they are complying with the rules, including the anti-diversion rules. So we have a dispute as to what the definition is. Genesis is, they can proceed dangerously doing what they believe the statute means and run the risk of a 340B death penalty, or can toe the line as HRSA says what the line is. Your Honor, this case falls squarely within the voluntary cessation line of cases when it comes to mootness. And we've cited in our brief, and I would direct the court to two cases from this court, Pashby, P-A-S-H-B-Y versus Delia, and then Wall v. Wade. And Pashby is a very similar case, Your Honor. The Pashby involved Medicaid benefits administered by the state of North Carolina. And the question was, under Pashby, certain beneficiaries were not being provided benefits for home health care. The Pashby plaintiffs sued. In the course of then they moved to dismiss the case as being moot. Judge Floyd of this court ruled that it wasn't moot and specifically pointed out that the recipients do not take issue with the practice of reassessment in general, but rather take issue with the eligibility criteria. And the eligibility criteria under Pashby, it was clear that there was going to be subject to reassessment going forward. Here, annually, Genesis has to file a certification that is complying with the rules. Genesis is subject to an audit. Now, in the brief, HRSA says, well, the chances of Genesis receiving an audit is remote because we only audited, 13,000 out of 30,000 last year or something along those lines. But the burden under the voluntary cessation line of cases, and the Supreme Court in the Laidlaw case says it's a heavy burden. And it's the defendant or the person who's claiming mootness has to establish that the challenge conduct will not reoccur in the future.
And government withdrew its sanctions and withdrew the letter withdrawing its regulation of you in this case, did they acknowledge that they had defined patient wrong and were going to define in a different way in the future?
Absolutely not. Absolutely not.
So the immediate action, which you were seeking to enjoin, was avoided, but the declaration about the legality of their definition was not adjudicated.
That's exactly correct. And that is what we had requested the lower court to adjudicate in our declaratory judgment action. And the court.
The doctrines you invoked are doctrines attached to injunctions where there's voluntary compliance. Somebody tries to avoid the injunction by voluntary compliance, but you had a claim not only for an injunctive relief, but you had a claim for declaratory relief, and you wanted declared that the inpatient definition that they were applying was contrary to law.
That's correct, Your Honor. That's correct. And the district court concluded that the actual controversy between the parties ceased to exist when HRSA avoided the audit findings. And as I've touched on here, the controversy still exists, is still active. HRSA has never said, okay, we're not going to apply this definition of patient that we use in the preliminary finding, in the final finding, in the letter approving the cap, and the 4 times in this case below, they set out their definition of patient and applied it. They vacated everything before we could get to court to challenge whether that definition was the correct definition, and then moved it to be moot. The district court agreed with them, and the district court said without an audit, that would allow this court to review the agency's unlawful definition of patient, and therefore the case is moot. And respectfully, we don't believe it is moot based upon the line of cases regarding voluntary cessation in the face of a challenge.
If I'm carrying your argument out, they never voluntarily accommodated the relief you sought in the declaratory judgment.
Well, that's exactly right.
In other words, that's a different issue altogether from the injunction, which was the government was trying to apply a definition that you contend was illegal, and they guess they didn't want it challenged. Be a different case, right?
We wouldn't be here. Absolutely wouldn't be here. But they've not done that. And, you know, I would point to the case of, which cited in the brief, it's one of the prison cases. I think it's a death row case. And in that case, the lawyers candidly admitted that we could go back and we could reinstate the conditions that we had previously. And in response to oral argument, I'd be curious what HRSA says today about that. Thank you.
If I could ask you one more question.
Oh, yes, sir.
I understand the rest of your argument rises and falls on the application of voluntary cessation exception to mootness.
That's our strongest argument. In our brief, we cited the capable of repetition, and honestly, this is not the classic capable of repetition case. But if they're allowed to do this, just voluntary cease the conduct, then
does that mean you're giving up the point that you and I discussed, which was
no, sir.
Didn't involve. They didn't voluntarily cease from applying the definition, and as far as you know, they're going to continue to apply it, and you have continuing requirements of reporting and so forth.
They're part of, and we're still living under the threat of sanctions if we don't toe the line.
We don't give advisory opinions.
No, this would not have this is not an advisory opinion, Your Honor. It has an effect.
It's advisory because there's no agency action against you. You want us to advise as to what this means. And therefore, once we do that, you say, aha, you can no longer enforce your auditing procedures against us because the court has told you what this means. That's what you want.
Well, certainly asking for declaratory judgment and injunctive relief, saying you can't apply your narrow definition that you seek to apply. Absolutely, that's what we're seeking. Thank you.
Thank you so much, Mr. Griffin. Mr. Springer.
Thank you, Your Honors, and may it please the court. The audit findings that precipitated this lawsuit have been fully voided. The audit has been closed for several years, and Genesis Healthcare was promptly reinstated.
Can I ask you about that? Because that goes to the heart of my questions to your colleague there. The government kicked them out of the program because they were based on a definition of patient that they disagreed with, right?
That's correct, Your Honor. In part, as well as not having auditable records. But
Yeah,
that's
right,
correct, Your Honor.
right. And so they come in and they're now injured. They have a federal question. I mean, the federal question, you have an agency action, which is to kick them out, sanction them. And they say two things. They seek to enjoin it, they seek to enjoin it, and they seek a declaratory judgment that your definition is wrong. Because they're going to continue year after year be in this program, which is year after year audits, which depend on the definition of patient. So they sought a declaratory judgment as to what patient means. You come in and say, we're not going to kick you out of the program. You're back in. Everything we said to you is void. But you did not reverse your position. But you didn't eliminate the relief they were seeking, which was you didn't address the patient issue. And you're now saying a court can't do that. But it seems to me that is an issue in the case that is not decided or not resolved by your voluntary withdrawal. You solved part of the problem, but you didn't solve the patient problem. And if you're right, that you can resolve the whole thing just by sending the letter and not agreeing with their position, it's hardly a voluntary cessation of what the relief they're seeking. Do you understand my question? It's the scope of your action is narrower than the scope of the relief that they sought. And so the case has not been fully resolved at this point. If we look at the case at the time it was filed, we have those two reliefs before us, and one of them is to decide the patient. So next year comes around, or the following year comes around, and they continue with their definition of patient, which they think is justified by the law. And you come back and you never said you won't sanction them for that.
Your Honor, I think the important point here is that there needs to be final agency action to review. There needs to be an application of the law.
How did you enforce it? How did you enforce it? In other words, you're suggesting that your letter is final agency action? I mean, you came in with a final agency position and enforced it in the court, and they're challenging that position. And they challenged it not only there, but they also sought an independent declaration under federal question that says you're wrong. And aren't they entitled to have a decision by a court that you were wrong on the definition under a regulation that they're they're still subject to that regulation?
Your Honor, they're not entitled to a declaration in the abstract, which is what we have here.
It's not abstract. This is enforcement. You kicked them out of the program. It cost them money. They want to be back in the program. You think that is abstract?
Your Honor, they've been readmitted to the program, and the agency voided its findings and the specific statement that they object to.
You don't want us to decide what the definition of patient is.
Your Honor, the reason that it would be improper for the court to decide that in the context of this case is that there's no longer a controversy. And the question of whether someone constitutes
There's a big controversy. You didn't resolve that question. You didn't agree with them. They say patient means patient. You say patient means a narrower class of patient. And they say that law supports their definition. That's an open dispute. And it affects them because they're under that regulation right now, day to day. Not only that, they have to prove it by audit year after year. So I don't know why that isn't a live controversy.
Your Honor, the other side is asking for an advisory opinion in the abstract, divorced from the context of any specific audit findings.
Opinion is an opinion that doesn't affect the injury. I mean, This is not advisory at all. They're engaged in this. This is their business. And you've said their business is wrong, but you don't admit you were wrong. You just say, okay, we won't enforce it this time, so to speak.
Your Honor, I think the important point here is that the agency's audit findings have been void. Those are not, those are not available to review anymore. And so Genesis is asking this court.
So what are you going to do with their claim? They have a claim, separate claim, identifiable claim that seeks a declaratory judgment. At the time they filed the action, it was a live complaint. I think I suggest it might still be. That's my questions. But they alleged that your definition of patient was wrong and that you're enforcing that against us. And we are a regulatory company subject to that regulation and ongoing regulation. Even today, as we stand, they're subject to your interpretation of it, and they want to change that. And you're saying because we withdrew the initial sanction that we imposed, they can't get that. But so tomorrow they go out and they function under a definition of patient, either as they think is what the law specifies or what you say the law specifies. I submit I looked at this very briefly, and it didn't look like all the qualifications to the word patient were what is being enforced, but that's an issue for a more full determination. The question now is whether there's a controversy, a live controversy, and I don't know how we address that claim. That's an open claim that has not been decided or voluntarily withdrawn.
Your Honor, I agree that the question is whether or not there's a live controversy. And here the controversy went away when the agency voided its audit findings. And what I will say is it's extremely common for Congress to issue a general directive and for the agency or an agency to issue guidance, providing sort of further details, but not addressing.
Let me follow some of the questions I ask opposing counsel. Is it your view of the case that there's no underlying subject matter jurisdiction because there's no final agency order? And if that's the case, what about opposing counsel's contention that there is subject matter jurisdiction because of the federal question statute?
Your Honor, I think there are multiple problems here. One is that there's no longer a final agency action for this court to review because the action that initially precipitated.
Under the APA, we would have no subject matter jurisdiction at that point. That's your argument?
That's correct, Your Honor.
Right. And what about the federal question statute?
Your Honor, the other side is pointing to the Declaratory Judgment Act, which is just a form of relief and still needs to be present within a particular controversy. Here again, because the agency has specifically voided its audit findings, there's nothing left for the court to review. And I think one thing that's important is if you look to the sections of the other side's complaint that they pointed to in oral argument today, for example, paragraph 66, what Genesis is seeking is just an abstract judgment about what the word patient means, divorced from the context of any particular facts. And in particular, if you
it alleged all those facts in its petition. I mean, its petition is fulsome. It alleged it how it's there, how it affects it, how it operates. There's a full lawsuit, and you didn't make it all go away. You made some of it go away.
Your Honor, the petition was based on, at the time, the audit had not been fully voided. When the petition was filed, the audit was still ongoing. Some changes had been made, but the audit was still ongoing.
Those are facts, aren't they? They're all live facts, and we determine all those questions at the time the petition's filed.
Your Honor, not when you're looking at the mootness doctrine. We have to look at what has happened since to see if there has been.
Mootness doctrine has to mean that the live controversy went away, and that didn't happen. So the jurisdictional question focuses on the complaint when it's filed.
Your Honor, I think Your Honor, we have to look at sort of both of these things in tandem with each other. And here, the thing that Genesis was challenging was the audit findings.
Which two things are we looking at in tandem?
Your Honor, I think it's both the Article 3 problem as well as the specific question of whether there's a final agency action for this court to review. And because the agency
if there's no final agency action, at least as far as the APA is concerned, then there's no subject matter jurisdiction.
That's correct, Your Honor.
Question of mootness at that. But Genesis has raised other bases that it says grants it jurisdiction in section paragraph 7 of its amended petition. So my question to you is, are none of those valid to grant subject matter jurisdiction? Or if they do, why is the case thereafter moot?
Your Honor, I think you can sort of analyze it in two different ways. One is that it's not valid to confer subject matter jurisdiction because with respect just to the Declaratory Judgment Act, Genesis is seeking an advisory opinion in the abstract. At least once you look at this through the lens of mootness and the agency's subsequent
Look at it at the
invalidation.
time the complaint was filed. Was it in the abstract then?
Your Honor, at the time, there was a final agency action
No,
for
I'm
Genesis
talking
to
about the
challenge.
declaratory judgment action under 1331.
Your Honor, at that time, yes, it probably would have been a live controversy because of the fact that the agency had applied the law to a specific factual circumstance and had reached a conclusion based on those particular facts. After that happened, the agency—
voiding letters from the agency came after the amended petition was filed.
That's correct, Your Honor. Yes.
So now you're in a question of would seem of mootness at that point.
That's correct, Your Honor.
Yeah, but I thought into mootness, but also back to Judge Nehemiah's question in terms of because you have a declaratory judgment still standing, well, you had jurisdiction because you had a question about the definition and they were kicked out and all those things were there. But once that went away, to say that jurisdiction continues just because that separate federal question was presented would mean that any agency like the appellant could freestanding say, I want a declaratory judgment. Because everybody stands, all the thousands of participating facilities would say, well, I stand with the threat of audit too every year. I want a declaratory judgment. Can you give me your opinion? Can you do that? Could you be able to do that without a cause? Because that action went away. The part about being kicked out and all that's gone. What remains is declaratory judgment. Could anyone come up and say, I want the federal court to tell us what patient means? What would your position for that?
No, Your Honor, no one could do that. They wouldn't have a live controversy because there's no impending threat that this law will be enforced against them. And that's exactly the situation we're in here because the agency has voided its audit findings. So the thing that Genesis was challenging has gone away, and they're now asking for a judgment in the abstract, divorced from any continuing controversy between the parties. And I would just like to note that these questions of whether someone qualifies as a patient are very fact intensive. And here the decision was made on a particular set of facts. Just to sort of throw out a couple non-exhaustive factors that matter, there's all kinds of questions about whether or not the covered entity holds medical records for the patient, whether the patient has had a prior relationship or prior visits with the covered entity, whether the healthcare professional is employed by the covered entity, whether there's a contractual or other arrangement like a referral for consultation. And those are the kind of things that a court would need to look at in order to make a decision within the context of a live controversy about who constitutes a patient.
Well, let's assume we go a year or two into the future and Genesis has filed whatever its annual report is for the applicable year, and they're audited again. Is there any barrier to the federal agency applying the same rules that it did in the initial audit, including the agency's definition of patient?
Your Honor, there's no specific barrier, and I don't want to get out ahead of the agency in determining what to do in a future case. But what I would say is that it's possible that even now Genesis's practices have changed, and we would need to look at this dispute.
Let's just assume everything's the same as it was in the initial audit. It's just later on down the road, chronologically, later year. And the agency applies exactly the same thing it did in the initial audit. It's free to do that.
Your Honor, I don't think that there would be any specific barrier to that, but again, it's remote about when that may happen in the future, if ever. And at that time, Genesis would be able to challenge that determination in court and get a ruling to the extent that the agency didn't determine that the
Let me ask,
audit
are
should be
they
closed.
still subject to regulation as we're standing here now?
Your Honor, they are subject to the statute.
And the same definition that was applied, right?
Your Honor, that's the guidance that the agency has issued. It's issued two forms.
I know, but I don't want to hedge on these things. I'm saying today they're subject to the same regulation with the same guidance that you enforced earlier.
Your Honor, this is non-binding guidance, so I suppose that Genesis does not have to follow it. But this is the normal way that things work out, where an agency issues some kind of guidance to advise the industry about how it thinks.
Are they still subject to regulation today?
They're subject to the statute. Yes, Your Honor.
Okay, they're subject to statute today, and they're still subject to reporting and conducting business with patients in the form, whatever form, which is undetermined.
Your Honor, I suppose the answer is they are required to give a certification each year.
Not only certification, but the certification has to reflect conduct, things that they do day in and day out.
That's correct, Your Honor.
Okay, so to day in and day out, they have to determine what patient means. And their reading of the law is different from the agency's reading of the law. And so they're now in this dilemma. This is a real actual problem for them, ongoing. Now, the question is, there's another audit in a year, and you'll apply the same guidance unless you've changed your position. Now, if you've changed your position, you can make the case go away. But if you haven't changed your position, it's going to repeat all over again.
Your Honor, there's no reason to think that the agency is just going to continually reopen and close audits against Genesis.
You have regulatory responsibility. You can conduct audits. You have to do them. You may not do them every year, of course. But the fact is they're still subject to it. The audit is just to confirm what they're doing. And at any point in time, you can come back and impose your very same definition. And that's, to me, what's at the heart of the rest of the suit. The declaratory judgment is just trying to clear that up. You may be right or you may be wrong. But this is not something in the abstract. This is happening as we talk.
Your Honor, I have two responses to that. The first is that, yes, the agency does conduct audits every year, but it only audits 200 out of 13,000 entities. It's a very small number, and it's a remote possibility about when, if ever, Genesis will be audited again.
But, you're losing my whole purpose. An audit only confirms what they're doing. The point is what they're doing may still violate the law or may be in compliance with the law as of today. And the fact that there's a potential for an audit, you're saying, oh, it's just a few, but there's a potential for an audit because your responsibility is to confirm that they're complying with the law. They say they are, but you have taken the position that they are not. Not only have you done that, when you withdrew your position earlier and reinstated them, you did not say, we're changing our position, which would have been very comforting to them.
Your Honor, I think the problem is that under that logic, anybody who's part of this program could sue the entity. Or
if they're adversely affected, sure, they can challenge it. That's what they're in court for.
Your Honor, but I think the important thing is that these controversies need to be decided on a particular set of facts. And here, absent an audit,
they've alleged the facts. They've alleged how they're enforcing it. They've alleged who they've dealt with. They've alleged the problems with the patients going one place and then seeking enforcement from them. And seeking fulfillment of prescriptions with them. And doing that day, they're still regulated. Your letter didn't eliminate the regulation, and the regulation, they argue, whether they're right or wrong, is illegal.
Your Honor, they allege the facts as they were at the time, but it's possible that since then, Genesis has changed its practices. In the intervening years.
You can ask them that. That might be a defense.
Your Honor, but here, the thing that a court would be reviewing are audit findings, and the agency has specifically voided those audit findings.
We would not be reviewing audit findings. We'd be reviewing a definition that the agency is applying against them.
Your Honor, I think that's the problem here, is that just reviewing that definition in the abstract is exactly what Article 3 prohibits.
Except you've issued a guidance and you've enforced it. And you say, oh, it's of no moment because we've withdrawn it. So then next year you're entitled to come in and do an audit. And you've also said there's no barrier for your not following your own guidance again. I don't understand why that isn't a problem.
Your Honor, I see that my time has expired.
Yeah, no, you can explain it as you wish.
Thank you, Your Honor. I think the important thing here is just that the Article 3 case or controversy requirement requires that things are decided within, that Genesis's particular rights be embedded in an actual controversy. And here, once the agency voided its audit findings, that controversy went away. And it's not the case that Genesis can just seek in the abstract a definition of patient, particularly when what a patient is depends on the particular facts that are in front of the agency at the time. And here, Genesis is just asking for a free-floating definition of what the word patient means. That's not something that courts do. Otherwise, there could be a flood of litigation of everybody just suing the agency.
We do it all the time. You know, when the prisons try to change their prison conditions, and they promise, they say they've now changed and they're not going to revert back and they want the case dismissed. We don't let that happen.
Your Honor,
the fact is they can change again, and we always bring up that possibility.
But Your Honor, here the agency voided its audit findings, it closed the audit, and it's never reopened an audit in the past. So that possibility of this audit being reopened is essentially off the table. And what Genesis is talking about is just the idea that at some hypothetical point in the future, they may be subject to the same requirement, even though their practice may have changed and may no longer violate the statute.
And their practice may have not changed, and they may be pursuing their practice in accordance with their understanding of the word patient. And they're violating your guidance, right?
Your Honor, the guidance that
Is that a question, yes or no? Are they violating your guidance if they follow their own definition?
Your Honor, I'm having trouble answering directly yes or no, because the guidance that we're referring to was in a March 2019 letter that was specifically voided. And so the agency could apply the same definition in the future, but that's specifically what Genesis is objecting to that has been voided and is no longer on the table.
So are you, I don't want to belabor this, but are you saying that the agency's guidance was only to Genesis?
No, Your Honor. The agency had issued it had issued general guidance in 1996 to the entire industry. And then within the context of this specific audit, based on the facts that it was seeing, it told Genesis what it thought the definition of patient was. It sort of elaborated on its prior guidance.
So is this definition of patients part of the 1996 statement, or was it made only in the context of this audit?
Your Honor, my understanding is it was made only within the context of this audit.
Has the agency enforced its definition, the definition that enforced against Genesis, has it enforced that same definition against any other drug company?
Your Honor, not to my knowledge. I'm not sure if there's been, if it has, at least I'm not sure that I'm aware of any litigation that's resulted.
Not litigation. I'm wondering whether they've enforced it or told somebody that's the way they have to do it.
Your Honor, not as far as I'm aware. And as far as I'm aware, it hasn't issued anything publicly that says that that's its position. And the only time that it made this statement was within the context of this particular dispute. And I just want to note one final thing that, I think one thing that's important to remember is that regulated entities all the time make decisions about how aggressive to be in conforming their conduct to the law. And to the extent that there are disputes when an agency applies the law to their particular conduct, those disputes can be litigated in court, as it could here, to the extent that in the future, Genesis is ever subject to another audit. Your Honors, if there are no further questions, we would ask that this court affirm the district court. Thank you.
Thank you, Mr. Springer. Mr. Griffin, you have some time reserved.
So before you get started on what you want to tell us, if you could help us with clarification. This guidance on the definition of patient, do we find that anywhere else in the agency's publications other than in the audit letters to you?
Your Honor, that there is a detailed and tortuous history of HRSA's attempts to define patient. And it's specifically pled in our amended petition starting at paragraph 32. But factually, it is in 1993, they proposed guidelines to determine what patient was. Subsequently, they issued additional guidance in the form of a letter that subsequently they withdrew. In about 2015 and 1996, they issued additional guidelines. In paragraph 35, HRSA provided no further guidance until 2015. And that's when they issued what's called the mega guidance, talking about what the definition of patient is, which is exactly what they used in our audit. But in 2017, they withdrew that mega guidance. Not sure why, whether it was in the face of a potential challenge or not, but they did. So this definition has existed clearly since 2015, and it's not just for Genesis. And you can go to
What I'm trying to make an analogy to here is probably a poor analogy, but if we're following something in the Code of Federal Regulations, we know we can go look at that. And then agencies have all kinds of other advisory, dear colleague, that sort of stuff, publications that they put out. So I'm still not quite sure from your answer whether if we went to find it as a statement of general application to people in your field, would we find that?
Your Honor, what you could still find to this day one portion of the guidance that is identified in HRSA's brief, and it is I'm trying to point you to the page.
In other words, does HRSA still broadcast to the world, this is the definition of patient?
No, HRSA does not broadcast to the world what was in their 2015 mega guidance, and the 1996 guidance that's still is still out in the public domain. It just talks about what a patient is, and it doesn't tie patient to the service that ended up with the prescription. But when they are using today their definition of patient, following what we say is the 2015 mega guidance, they cite to the 1996 guidance, but that's not what the 1996 guidance says. And that's why I said, Your Honor, this is tortured, but it's intentionally being tortured in our view by HRSA, and we don't know why. But the fact of the matter is, and I don't think they can just come up with one standard for Genesis and another standard for every other covered entity in the country. I mean,
right, but if there's no standard that they have out now, what could you get a declaratory judgment on?
They do have a standard. It's an operating standard. It's in their audit guidance, and you see it in the initial audit finding. You see it in the preliminary audit finding. You see it in the final audit finding. You see it in the September audit finding when they reinstated this, and you see it in their letter when they approved the corrective action plan, and they say, but remember, in order to have a patient, it has to be tied to the prescription. And that is that.
Answer the question before that would effectively say, forgetting about what they told you in the audit in terms of agency action, agency guidance, that when they had said, whether in 15 or 17, this is what you have to define a patient as, they withdrew that. Not just for you, but for everybody.
No, Your Honor, they withdrew that document from the public domain and saying, we're withdrawing the 2017 or the 2015 mega guidance, and we withdrew it in 2017. But they did not stop enforcing that standard, that criteria. And that's what they used when they came to Genesis in 2018.
So they're enforcing an unpublished criteria?
Yes, they currently are. I know it's
Well, then you're asking the declaratory judgment to really opine on SOP, a standard of procedure, an audit procedure, so we will become accountants.
we're asking the court to address the definition of patient, the criteria that is currently that was being used by HRSA when they did this.
That's a fluid question though, because it's not just defining patient, it's also in the context of how you are applying it. So what you're saying is that if that's the law, then you get a declaratory judgment. That'll be based upon your particular application, the standards of procedure for your audit, and that would open the door for the other 13,000 people to say, well, I want that one too. Let me get a freestanding declaratory judgment. Each one of them would be based on the facts of those things. It's a dynamic. It's not just patient, but it's in the context of how you're using patient. And I understand that because you're very, very clear and a very noble mission you have, because the point is that these people can't get these drugs like if you do it that way. And that's a wonderful policy and human act. So, but that's broader than, that's a policy question more so than a definition almost, because it's all intertwined, makes it difficult for you to operate. I understand it, but you say that can be a freestanding now declaratory judgment. That's the question I have.
Well, certainly we're getting into evidentiary facts that are not in the pleadings. If you accept the pleadings, which when you do a motion to dismiss, and we have pled that is the standard that they use, and they have never said we're not using that standard. They didn't say that here today. They said we may or may not use it in the future. They never disavowed that standard that they used against us, and frankly, they're using in the industry. On the question of subject matter jurisdiction, declaratory judgment, I just want to point to Judge Harwell's order in record 212 and 213, where he addressed this issue that's now being discussed, that the Declaratory Judgment Act doesn't give an independent basis for jurisdiction. He disagreed. He gives his analysis, and then he goes back to there's no case or controversy, which we disagree with. And HRSA never argued on this appeal in their briefs that declaratory judgment is not an independent basis for jurisdiction. Thank you.
Well, the statute requires another statute for jurisdiction. Declaratory Judgment Act provides a remedy for cases in federal court, and your jurisdictional thing it's a federal question under 1331.
Yes, sir.
We're talking about federal law.
And that's exactly what Judge Harwell said. He said the court possesses an independent basis for jurisdiction over the parties, for example, federal question or diversity. And here we've got federal question. Thank you.
Thank you. Sure.
One more thing. It meets with your approval and Judge Niemeyer's. Maybe it's just my confusion, but I would like to ask for a 28J letter from you, which the government can respond to, that tells us where we find, other than in the audit they did for you, this guidance that deals with the definition of patient, because I'm still unclear whether this is something that's extant and can be applied to you and all the other people in your field, or whether this ended up sort of being a one-off thing that just came up in your audit. Does that make sense?
We're happy to provide that with the court, Your Honor.
All right. I'd appreciate that.
Thank you. How soon would you like it?
Get to it.
I'm going skiing with my family tomorrow, but I'll have it to the end of next week if that's okay.
Sundays.
Sunday. Right. Thank you.
All right, counsel. Counsel, thank you so much for your arguments, and we appreciate it. We can't come down and greet you, but nonetheless, we appreciate very much your arguments, and we wish that you will be safe and stay well. With that, Deputy Clerk, would you please adjourn the court for this? I was not morning it now, but I guess for later this afternoon.
This honorable court stands adjourned until 2 o'clock. God save the United States and this honorable court.
Thank you. Always a pleasure.